Judiciary Committee hearing. We have a quorum, so we're going to go ahead and get started. I'm going to ask Senator Kennedy if you'll open us up in a word of prayer.
Heavenly Father, thank you for this day. Thank you for the blessings to get to serve the people of Georgia. Please forgive us of our sins. Please give all of us guidance, wisdom, and judgment as we go through issues. Bless our families wherever they may be. And bless those that are in your need. In Christ's name, amen.
Thank you, Senator Kennedy. As always, we have sign-up sheets up at the podium. If you want to be heard on one of the bills, if you'll please sign up. And I think Patrick has all the sign-up sheets. Now, anybody else need to sign up before he gives them to me? All right, thank you very much. We will start with Senate Bill 197. Senator Jackson.
Good morning, Mr. Chairman. Somebody's cell phone is here on the counter. They have beautiful children.
At least that's the picture.
Well, I assume, yeah.
Anybody leave a cell phone at the podium? I'm sure they'll be missing
Somebody
it.
will.
If you want to leave it right there, they'll. You recognize the kids, Rusty?
Yeah.
Okay. All right. I like how you paused like it wasn't yours and. All right, we are working off LC 280189. Is that what you have, Senator Jackson?
That's correct.
All right, the floor is yours.
Well, good morning. Thank you so much for hearing me on this day. You all might be used to seeing me coming to talk about stalking, because that is once again the bill that I bring, the topic of the bill that I bring before you. Just looking at the bill directly itself, what we've done is currently Georgia law does not, when it comes to stalking and a definition, it says that the place in which stalking can happen does not include a person's house. And so we've struck that, the other than, and added the word including. Just by way of background for this bill, I spoke with the bill's original author, Representative Mary Margaret Oliver, who helped make this statute in the 1990s. And when I asked her, why is there a carve out for the residents, she said, well, you know, back in the 90s, we didn't have sophisticated technologies like social media or tracking devices to consider. So we were just thinking about someone being stalked from their couch to their, dining room table, and that didn't really seem like something one could prove. So we had that carve out. Just so you know, Georgia is only one of 3 states that has this carve out. And so should we pass this bill, we would be aligning ourselves with a more national standard. So I know some of you are wondering, what does this even look like? I can't imagine, how does this work? So let me just tell you a story from a person who had this experience to try to give you guys some light to this situation. I've changed the names for their privacy, of course. So after enduring years and years of verbal and emotional abuse, Susan filed for divorce, but because she worked part-time and was the primary caregiver of 3 children, she hoped to remain in the residence with her husband, Dave, for the stability of her children. And he refused to move out, so they had to stay inside the residence together while the divorce attorneys kind of worked out a settlement. As time progressed, Dave began to accuse Susan of having ulterior motives for the divorce and accused her of having an affair. And that's when the house became increasingly hostile. He began to interrogate her about gonna let Susan leave him. One day she took her car to the mechanic to have some work done on it, and they discovered a tracking device under the bumper of her car. And then she discovered that her phone and her laptop had been tapped with spyware that was allowing Dave to see all her emails and listen to her private phone calls. He worked from home, and so he was always there. And for Susan, her part-time job was kind of her only break from Dave, from his constant harassment and threats. And he even started to call and text her whenever she was away from the house. But then it also became the norm that he would call her 30 times a day and send her 100 text messages, even when they were in the house together. His actions became increasingly threatening, so she went to file a police report about Dave. Unfortunately, the police told her that because she and Dave shared a residence, Dave had not committed a crime. The police could not charge Dave with the crime of stalking because they lived in the same residence, and Susan was unable to even obtain a temporary protective order. There was nothing either the police or the judge could do with the law as it's currently written. And of course, by this point, Susan had run out of money to keep paying for her attorney, so her attorney withdrew and her divorce was stalled. Left without financial resources, legal representation, or the law on her side, Susan was truly trapped. This is just one story of many people who find themselves being victims of stalking within their own home. What I want to just add to this is this really important thing for us to know. Stalking is kind of a warm-up crime. We learned this, I think, in the last time I talked to you all about stalking. And what we've discovered is that in 58% of domestic violence incidents that end in death, so in 58 fatalities involving domestic violence, stalking happened within the year before. It's a warm-up crime, and so should we close this little loophole, we could really begin to save lives. Mr. Chair, if you would allow, I have Judge Whitaker here, who she has court to get to. If you would allow for her to go ahead and speak to this before I take questions. Thank you.
Good morning, Mr. Chairman and members of the committee. Thank you for the opportunity to speak on behalf of this statute. My name is Paige Reese Whitaker. I am a Fulton County Superior Court judge, and I'm also a member of the Georgia Commission on Family Violence, and I am here to try to help answer any questions y'all may have about this law or about the legal implications of this change. I will say that this is a common sense modernization of this statute to eliminate a carve out, as you just heard, that currently exempts something that is clearly criminal conduct that follows every element of the definition of stalking. As long as that is done in a defendant's home, it is outside of the reach of our criminal laws. And as you also heard Senator Jackson say, this would certainly bring us in line with the vast majority of the other states. So I'm happy to answer any questions about legal implications.
All right, thank you, Judge. Well, since she has to leave, we'll go and take any questions you have for the judge before she goes from the committee. You have no questions.
No
Thank you
questions.
so much for being with us.
Okay. I hope to be able to help y'all out a little bit. So I encourage y'all
hold
to.
on. We knew that you talked too long. There you go. And we do now have a question. Senator Hatchett.
Hey, I just wanted a point of clarity. I think a previous bill that Senator Jackson brought, if I'm not mistaken, dealt with TROs, TPOs, which aren't allowed to be given to someone if they live in the same house. This bill, how is that going to affect that? And would a remedy for stalking be a TPO? And in this situation, would that allow a victim to get a TPO against their stalker?
Yes. So currently you can get a stalking TPO if you've got to go to a judge with a verified petition, and you have to set out specific facts that establish all of the elements of stalking. And because of the exemption, if the stalking occurs in the defendant's house or in a house that the defendant and the victim share, then it's exempt. And so a judge, even if they heard every element, would have to deny the stalking TPO. But if we eliminate this carve out, then yes, you would be able to get a stalking TPO.
Okay, thank you.
All right.
Any other questions from the committee for Judge Whitaker? All right, thank you very much.
Thank you very much.
And Senator, if you want to step back up, and we'll open it up for any questions for the author of the bill. All right, no questions at this time. There are a couple of folks who signed up to be heard on the bill. We have Kylie from the Georgia Commission for Family Violence.
Good Good morning, Chairman Strickland and
Morning.
members of the committee. Thank you for allowing me a moment to speak on this very important topic and this change that has been proposed in Senate Bill 197. My name is Kylie Elliott, and I am on staff with the Georgia Commission on Family Violence. I'm also a fellow of the YWCA's Georgia Women's Policy Institute, working to support this legislation. Prior to my work for the commission, I worked in the field of domestic violence for over 10 years, providing legal advocacy and direct legal services to victims of violence in Georgia. And I'm here today to convey the support of the Georgia Commission on Family Violence and other community partners for this legislation, and to share a bit more about the problem of stalking that exists in Georgia and nationwide. So each year, approximately 4% of men or women and 2% of men experience stalking in the United States. But in Georgia, that equates to roughly 312,000 men and women each year that are victims of stalking. That's enough to fill State Farm Arena over 15 times with the number of victims each year. And more than half of those victims are stalked by their current or former intimate partner. Simply put, stalking is not a stranger in the bushes kind of problem. It's a problem that's impacting our families in Georgia, and it's a significant lethality indicator for intimate partner homicide. In fact, our national data tells us that 76% of women who are ultimately killed by their former intimate partners experienced stalking in the year prior to their death. Additionally, both national research as well as our studies that we have done in Georgia at the Georgia Commission on Family Violence all confirm that stalking does occur within the context of relationships, and within that sense, it is largely an invisible crime that currently goes without consequence for the perpetrator. So just to take it back one step, let's talk about what stalking really is. OCGA 16590 lays out the requirements for stalking, and they're pretty significant. They require that a pattern of activity must take place. That means no single action that anyone takes can be stalking. The activity has to be both intimidating and harassing in nature. It has to place the victim in reasonable fear, and currently it must also happen in a location other than the perpetrator's home. And that last component is obviously the part that SB 197 would address. And when we take a look, like Senator Jackson said, at state laws, we find that there are only two other states besides Georgia, that's Illinois and Wyoming, if you're curious, that have this component. And this means that this behavior that would otherwise be considered stalking when it happens in Georgia cannot be addressed if it takes place in the perpetrator's home. And this implication of this provision is that, sadly, we must not believe that partners that engage in stalking behavior should be held accountable if he or she lives with the victim. And as Senator Jackson said, from speaking with the legislators that drafted this legislation, we don't believe that was the original intent. But it's still the end result, and it's not one we should allow to continue. SB 197 proposes a simple fix that removes this exception and affirms that location doesn't matter, behavior matters. Stalking is stalking, and it's a crime regardless of the location where it takes place. And this change ensures that a person engaged in harassing and intimidative behavior constitutes stalking and is held accountable. Finally, let me just give you one last example of how this plays out that kind of will draw a slightly different implication. So I've got a story, and I've changed the names of a current case that's happening here in Georgia. I spoke a couple weeks ago to an advocate up in North Georgia that was working with a client, and she explained to me that her victim, Rachel, for example, is married to Brian. And together they have a teenage daughter. And last year, Brian began an affair where he eventually moved his new girlfriend, Amy, into their home. Rachel didn't agree with that and didn't want that, but Brian is extremely controlling of Rachel, and she was afraid to stand up to him or leave the relationship. And about a year after he moved Amy into their home, she reached her breaking point. Things were so bad in her home, she couldn't take it any further. So she went to the police and she asked for help. She received none. She went to the local domestic violence program to try to apply for a protective order because she told them she felt trapped and she was afraid of Brian. Rachel told authorities that and advocates that Brian monitored all her phone calls and texts, and he had placed a tracker on her car so he knew where she was at all times. And Brian would call Rachel at work and make sure she was there. He'd call her boss and make sure, hey, is Rachel really at work? And to make sure that she wasn't doing something that wasn't allowed or approved of by Brian. When Rachel became frustrated and resisted Brian's control, he would threaten Rachel that he would harm her or their daughter if she wasn't compliant. And Rachel knew that Brian meant business, but he was smart. He kept his threats just vague enough that she would never have proof to be able to get him on another kind of charge. The advocate asked Rachel, "Has Brian ever hit you?" Rachel said no. Sadly, the advocate and the police both had to give Rachel the same message. "We're sorry, there is nothing we can do for you because he hasn't committed a crime while you guys live in the home together. He's allowed to track you in those ways." 1 week later, Rachel left, and 1 week later, Rachel returned to see the advocate. The advocate barely recognized Rachel because her face was so bruised and battered. Rachel explained to the advocate that Brian used his trackers and had found out she'd been to the courthouse and the police to try to get help. And when Brian discovered that she had lied to him about her whereabouts and possibly disclosed what was happening in their home, he smashed her face into a table, breaking her nose and badly bruising her face. And guess what? Now Rachel qualified for a protective order and was able to get assistance from law enforcement and the police. Only after obtaining this protection did Rachel feel safe enough to disclose the full extent of what was happening in her home. Yes, it's true. Prior to this incident, Brian had never actually hit Rachel, but what he was doing was he was sexually trafficking her for his own financial gain. And that gave him good motive and good cause to keep an eye on her and track her and monitor her so intensely. Brian stalked, threatened, and intimidated Rachel into keeping this fact that he was sexually trafficking her a secret by first making her believe she could get charged with prostitution and then threatening her when that no longer worked that he would use her daughter in her place if she left. This story to me was heartbreaking, but I hope you get the same takeaway. If this law was corrected, she would have been able to get help before the violence started. And she would have been able to get out sooner and get safety for her and her daughter. We could have prevented that. And that's what this law does. It simply allows the actions that make up stalking to stand on their own merit without an abuser escape clause. It gives victims the critical protection and resources they need sooner, and it saves lives. Thank you again for this opportunity to share my testimony, and I'm happy to answer any questions if anyone has any. Thank you.
Thank you, Ms. Elliott. Any questions for Ms. Elliott? All right, we have one other person. Thank you. One other person signed up to speak. Ms. Maisie Lynn Causey with the Georgia Association of Criminal Defense Lawyers.
Good morning, Chairman and Committee. Thank you so much for hearing from us today. I rise in opposition to Senate Bill 197, as I'm sure you're not surprised. You know, just the other day, we were in a hearing over in the House chamber regarding porch piracy. And a strong theme throughout that testimony was how our homes are our castles, and that these are places that should be protected. We should be safe and, steady in our homes. And I believe that's true, even for the women that we've heard about today. Of course, I have great sympathy for the tragic stories that we've heard today, but I don't think that means we should transgress on another person's home. Senator Hatchett, with all due respect, we've been hearing a lot this session about TPOs. The reality is you can get a stalking TPO. You can get protective orders more readily when you do cohabitate or when you are in a relationship with one another. The situations we've been hearing about this session are more about dating relationships, more arm's length relationships that the communities have been trying to get more protections for. So the examples we've heard about today are actually prime for getting protection under our law today. When you're cohabitating or you share children, right now our law protects you. And even some of the examples we've heard today, for instance, if someone's car is being tracked, just on the front page of the bill, you can see that at lines 10 and 11, if you're being placed under surveillance, you're already protected under this law. We also have, you can institute certain conditions of bond when you are in a criminal prosecution scenario, which several of these examples would have warranted. I can't, it's impossible for me to come here and address line by line the arguments that you've heard without knowing all the details of the story. I certainly can't speak for the law enforcement officers who, it sounds to me like, have not been properly enforcing the laws that you've already passed. It certainly sounds like there are misunderstandings about what is allowed and what's not allowed. For instance, we have under our law right now terroristic threats. All you need to do to perpetrate a terroristic threat is to threaten to commit any crime of violence, and that's 161137B1A. The alleged victims in these scenarios are in the best position to remove themselves from the alleged perpetrator's home. I know it's very difficult in some of these scenarios for women to get out of the homes that they live in. There are financial concerns and constraints and other things at play. But we have plenty of means under our law right now to protect women with stalking TPOs. You can get family law orders. Like I said, there are bond conditions that can be in place. And there are precious few examples that have been given here today that I can think of that are not already covered. So we would ask you to just leave the law as it is, realizing that when someone is accused of a crime, they are presumed innocent until they are convicted. And when these scenarios are happening, when they're alleged, we don't know on the front end what's really going on. And it does sound like, especially in the last scenario that we heard about, there were many more layers of criminal activity happening that could have been addressed. And again, I can't speak for why this all wasn't. But I can guarantee that the prosecutors that I've come up against in the courtroom would have been able to charge many of these scenarios with crimes under our current code and protected the women in issue here today. I would stand for any questions that you have.
Just make sure I'm clear on line 12 of the current bill is the existing law. For someone to commit the offense of stalking, they have to have this contact for the purpose of harassing and intimidating the other person, correct?
Yes, sir.
Okay, and we're not changing that.
Not at all.
Okay. Any questions from members of the committee? Thank you very much.
Certainly.
No one else signed up to be heard on the bill. Anybody else that wanted to be heard? All right. Any?
Do you mind if I rebut some of that?
Sure, because kind of quickly.
So for terroristic threats, nobody can be convicted on the uncorroborated testimony of the victim alone. So it's not true that terroristic threats would cover that behavior or would lead to a conviction. With regard to any TPO, you cannot now get a stalking TPO because our statute exempts anything that occurs within the home from being considered stalking. So that is not available. A family violence TPO is not available unless there is a felony or other crime of family violence, which a lot of these scenarios have not covered. With regard to the sexual trafficking, I think the point was that the woman was so terrorized that she was not able to feel like she could let the law enforcement people know the extent of what all was going on. And with regard to, yes, of course, everybody is considered innocent until they are proven guilty beyond a reasonable doubt. But that's none of that is going to change. The literally only thing that is being changed with this proposed legislation is to take out this carve out that 47 states have already done. So I just wanted to make sure that y'all understood a lot of this is not currently within the reach of our criminal laws.
All right.
Thank you.
Thank you, Judge. What's the pleasure of the committee? We have a motion to pass by Senator Parent. Do we have a second? Second by Senator Rhett. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? You pass unanimously. Thank you very much. Next bill, before we get to that, On the agenda, we have Senate Bill 151. I forgot to announce this earlier. That bill is being removed from the agenda for today. We do, for the committee's sake, have a time available tomorrow at 10 o'clock for another hearing. And so it's likely that bill will be heard tomorrow at 10. And if we are not able to get through everything today, we may also have some of these other bills for tomorrow as well. So we're now on to Senate Bill 162. Senator Beach.
Mr. Chairman, members of the committee, thank you for allowing me to present Senate Bill 162. And this is my 9th session and my first time before the Judiciary Committee, so I feel this is a special day. So what I bring before you is Senate Bill 162 is very simple. It's the Blue Ridge Judicial Circuit, and we currently have 3 Superior Court judges, and we are now asking for a 4th. The last time we've had a Superior Court judge added to the circuit was in 2006. Based on some annual data-driven studies that were conducted by the Administrative Office of Courts, which looked at our caseloads from 2017 to 2019, the Judicial Council met on August 14th of 2020 and ranked our circuit second as far as a need for a new judge. There were 8 total circuits that were qualified for new judges. We were, again, ranked number 2. If you look at our criminal caseload, averages criminal cases 2,979, and then civil cases 2,611. Right now, currently, each judge is carrying a load of about 1.5. 1.2 is what the norm is or the threshold is for a new judge, and we're at about 1.5. And if you look at our population, since 2010, we're at 214,000 citizens in Cherokee County. We're now at 271,000, and we're continuing growth up in that Cherokee area. So we really do believe there's a need there, and right now, to help with the caseloads, we've had 2 juvenile court judges and a senior judge assisting to serve our caseload through the system. So with that, Mr. Chairman, I would ask for the approval of this. I know you have spoken to my district attorney, and she has said she's that's the other thing that I would tell you is over the past 5 years, we've seen a 21% increase in felony cases to the DA's office. So this is very needed, much needed, and I would appreciate y'all's consideration. With that, Mr. Chairman, I'm done, and I will answer any questions.
Thank you, Senator. Just for the committee's sake, for those of y'all who have not had one of these bills in committee before, we do try to rely on the study that's done by Judicial Council, the recommendations they make when it comes to adding new judges. And so the important thing you alluded to is you were number 2 on that list as circuit was for this last
out of 8,
year.
we were number 2. Yes,
Okay.
sir.
And
I
I
have
had
a letter from Chief Judge Melton to talked about that.
And there's a process in place where they review all the circuits in our state and vote on that at a meeting, correct?
Yes.
Okay. Senator Cowser has a question.
Thank you, Mr. Chairman. Who's number 1 on that list?
Number 1 is the South Georgia Judicial Circuit. Now, I don't know exactly where, in his letter, South Georgia Judicial Circuit is 1, Blue Ridge 2, Mountain Judicial Circuit 3, and Coweta 4, Clayton 5th, Atlantic 6, Northern, and then 7th, and then 8th is Atlanta.
Okay.
I have a letter here from Chief Judge Melton, if you'd like to. I should have distributed that. I apologize. But
do you know what the population of that judicial circuit is? I noticed there are 3 judges already, and this takes it to 4. Just wondered how many citizens living in that judicial district.
271,000 in Cherokee right now.
Okay.
And I can tell you, Mr. Chairman, it's growing. There's houses being built as we speak. So we're going to continue to see growth up that 575 corridor in the Cherokee County area. So,
okay. Thank you.
This circuit just includes Cherokee County?
Yes, sir.
Okay. Any other questions for members of the committee? Nobody signed up to be heard on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Kennedy. Do we have a second? Second by Senator Cowser. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? It passed unanimously.
Thank you, Mr. Chairman,
Thank
members
you,
of the committee. Thank you.
Don't want to always be that easy in Judiciary, Senator, so come back and see us again.
Thank you. It'll be another 9 years.
Not sure I'll still be around that long. We are going to go a little bit off the agenda and move on to Senate Bill 18. So you can present from there if you'd like. There is a substitute that was not in your folder that's being passed around for your consideration, and I'll have Senator Jones explain that to us, and the committee can decide if you want to move forward with the substitute or go a different direction with this bill. So you're Mike 4. The floor is yours.
Thank you, Mr. Chair.
Let me make sure, I'm sorry, I'm on the last bill, to make sure I'm clear for the record. What was the LC number in the last one? I just pulled it aside. Oh, 1 second, okay? We were on LC 412923 for Senate Bill 162. They got the motion to pass. All right, and on this bill, we have in front of us a new substitute 413054S. Is that the version you're presenting?
That's
today?
correct, Mr. Chair. That's
Okay.
correct.
All right, go ahead. Sorry about that.
Yes, this is substitute LC 413054S, substitute Senate Bill 18. The substitute basically is trying to make sure that the offenses would not be ex post facto. The original amendment is actually in your packet that you'll see. The amendment is in there, but we've already codified that within a substitute. Basically, what this bill does is eliminates the statute of limitations for the offense of rape, aggravated sodomy, and also aggravated sexual battery. All of these offenses actually involve force on some level, and also involve, of course, against a person's will. Rape being forcibly against a person's will, aggravated sodomy, force and against will. Aggravated sexual battery is with a foreign object and, of course, without consent. And this would eliminate the statute of limitations, which is currently 15 years for those offenses. This would bring Georgia within the ambient of 10 other states, those being California, Illinois, Kentucky, Maryland, North Carolina, South Carolina, West Virginia, Wyoming, New York, and also Virginia, which has done similar type legislation. The major issue here, and of course I want to address the major issue, which of course is, well, if you eliminate the statute of limitations, what does that do to defense or something, the defendant's rights or something of that nature? I would argue and I would say that this body has already eliminated statute of limitations into two levels dealing with the area of rape or sexual assault. Number one, there is no statute of limitations if DNA is found in a particular case. And so in a particular case, if a person's DNA is found, there is no current statute of limitations if DNA is used in proving that particular case. But here's the key thing to that, and I would say that what we did when we actually established that DNA exception is we're basically allowing the process to go forward. The process meaning that there still has to be a grand jury indictment. The process meaning that the police still have to investigate. The process being that there still is going to be a defense, there still is going to be a prosecution, there still is going to be a judge, there still is going to be a jury. The fact of the matter is, even if DNA is part of that equation, it does not eliminate the most important part of the equation, which is the consent aspect of it. DNA does not eliminate that aspect at all. It just brings one particular person into the ambient of potentially having committed this particular crime. It doesn't solve the quote unquote the crime at all, because that person could easily say, yes, we absolutely did have sex, it was consensual. That issue is still completely on the table. Nothing separates that. So when we have the argument or the conversation about, well, it becomes a he say, she say, that has not changed. This body has already made a decision that they're willing to allow the process to go forward. So that issue about, well, it's one person's word against the other, we've already established that we think that the process will work, and that process will still work. Nothing has changed in that situation. It still is going to be, if you want to say it that way, one person's word against the other on the issue of consent. Second aspect that we've also eliminated the statute of limitations for is where you have person who's under 16 years of age. If you're under 16 years of age, there's no statute of limitations, of course, for rape, aggravated sodomy, trafficking, or also incest. Once again, this body has already said that they trust the process. Nothing about the fact that the victim's under 16 changes the fact that statute of limitations is eliminated, changes the fact that you still have one person saying what another person did. But we're saying that under those circumstances that we believe that the process will still go forward. Absolutely nothing has changed because the victim is necessarily under 16. everything that a person may be concerned about, well, it's one person's word against the other, it all still exists. And we've eliminated the statute of limitations under those circumstances. All of that still exists. So what I think this body did was say that we're trusting the process. We're trusting the police. We're trusting the grand jury indictment process. We're trusting the judges. We're trusting the defense. We're trusting the prosecution. We've eliminated the statute of limitations already in those circumstances. So therefore, the question becomes, if those two exceptions do not apply, do we still trust the process when we're dealing with just adult women without those two particular circumstances? And I would say that the process will still be the same. I would also make note that just this body, this particular Judiciary Committee, just last week passed a bill, if you remember, making it a felony if you were going to be a coach and you have sexual relations with a person that you have a mentoring relationship with. And everyone on this panel agreed that that should take place. But what's interesting about that, even though all of us became I think even the author became emotional about it, is if that young lady was to wait for whatever reason, then all of a sudden we would not believe her. Remember, that case has not changed. That case today, that case later is still going to be one person's word supposedly against another. That's what that case is about. And so to say that what we felt that day when we heard that testimony would go away because of an arbitrary line of statute of limitations has been breached doesn't make any logical sense. So on one level, we're perfectly fine, but what if she was to have waited because he was her coach, because her father knew that person, and because of that, she could not go forward? The very same reason that we changed the law, we're attempting to change the law, because of that mentor relationship, because he was her coach, that's the very same reason she may not come forward. That's the very same reason she may not come forward. And so what we're saying is, we'll believe you now, but 15 years from now, we will not. Now all of a sudden we say it becomes he say, she say. Now all of a sudden we're going to say that this arbitrary line that we've created, that we've already eliminated in two other circumstances, now will bar you from coming forward. And I would say that takes away our trust of this process. And if you remember something that was very telling, even the prosecutor himself said initially he was like, well, this can't be true in the sense that maybe there's a misunderstanding, because a coach wouldn't do that. It tells you something about even the process that we as prosecutors, not me anymore, but prosecutors have to go through. It's not going to be a circumstance that all of a sudden, where you have someone who has a question mark today, is just going to run to the courthouse 15 years from now and just start indicting people then. If he had that question mark today, it lets you know that these questions already exist and that persons are going to be very vigilant in how they approach these particular questions. And that's not going to change because this line has been breached, that now all of a sudden, any questions leave them today, that now they just run to the courthouse and start indicting persons. This is just not how it's going to work and not how it's going to be. And so I would ask this body to continue to trust the process that we trusted also last year. This bill passed this committee last year also. And continue to trust the process of prosecutors, the grand jury, the jury, the judge, the defense attorneys, and let's go forward and join the other 10 states and eliminate statute of limitations. And with that, Mr. Chair, I will leave it open for questions.
I have one question on your draft. Help me understand, line 19 still has the 15-year statute of limitations for forcible rape, and how we reconcile that with our changes, of course, on lines 13 and 14. Just I'm having trouble reading it.
And as line, if you have to bear with me, which lines are we looking at here?
You're on 3054S. Is that right? Okay. So on line 19.
Oh, 19. Okay.
We still have the 15-year for forcible rape statute of limitations. But then, obviously, what your bill's doing, the intent of it on lines 13 and 14 is removing a statute of limitations for those three offenses. Is there some reason we still have that provision on line 19 in the bill?
No, Mr. Chair, no, I think that actually should be struck. That line there should be struck, Mr. Chairman.
Because I'm assuming there's not a separate offense for forcible
That's correct.
rape.
It's not.
Okay.
It's not.
So on the same note, on line 15 where it says, except as otherwise provided in subsection A, is that supposed to be subsection B? Or is it supposed to be subsection A there? Just having trouble reading it.
And I think that may be subsection. Well, I believe it is articulating subsection A when it says, no, it would be subsection B. You're correct. I apologize. It would be subsection B for crimes of rape, aggravated sodomy, aggravated sexual battery. That's correct.
I know the hours late on the bill. I don't know who was working on the last draft. Or do you want to hold for a minute to get any stuff cleaned up, or can we amend it here? So make sure we get it right for you.
Okay, I think we can amend it.
Okay.
That would be subsection B on line 15.
We recognize Senator Hatchett.
Senator, is on line 15, it looks like in the original bill, murder was to be included. And I'm just wondering if line 15 should now read subsection A or B. Would that be the intent that you're trying to have with this bill?
Well, we don't want to exclude murder, obviously, so that would stay in there. So if that would satisfy that particular, I think before it's always read just except as provided in line in subsection B, but certainly I don't want to exclude subsection A, which is a murder aspect of it. So from a cleanup purpose, we could use A or B. I understand what the senator is saying, but yeah, I mean, but it wouldn't. I think for cleanup purposes, we could say for subsection A and B or B, correct?
The only caution I'd give you is that's not currently. This is currently subsection B without saying except as provided in subsection A. Instead,
Right.
it cross-references section 17-3-2.1, which I don't have in front of me. So that
Oh, okay. I see what you're saying.
I don't know if we want to rewrite that without
No.
knowing for sure
Yeah.
that we're getting it right. Senator Kennedy. Excuse me, Senator Calzert.
Thank you, Mr. Chairman. I just had a couple here to make clear on some things. Okay, so right now, a charge for murder can be brought anytime from when you're born until you die. There is no limitation on when you can
There's no
bring
statute
those
of
charges.
limitation. That's correct.
Most other felonies, you have to bring your criminal charges within 4 years. We have an exception here where it's 15 years already. We've lengthened it for rape.
That's correct.
And in their own language here in the bill where you're quoting the code section down there at 18 and 19, any other crime where you can be punished by life in prison or death still has to be brought within 7 years.
That's correct.
And you're now taking something that's less serious than that warrants the death penalty, and you're eliminating the statute of limitations whatsoever. So like Brett Kavanaugh could be sued for or prosecuted for aggravated sexual battery or something 50 years after the event occurred, when it just so happens that he comes up for, you know, confirmation, or when one of us decides to run for higher office. We're opening these defendants up for charges that there's no DNA evidence, there's no corroborating evidence, there's no confession. You know, there are a lot of other states require more than just the allegations, unsupported allegations of a victim. Am I reading that's the effect of this? I understand you're trying to protect victims, and I applaud that. But that other side of that equation of the defendant concerns me. We've had these in place for, you know, literally over a century for a reason.
Yes, sir. I would let's start off. I would say first with the I know we're just kind of using pop culture, when we say Kavanaugh, of course, that would not have been rape. That situation was not rape. It would not have been aggravated sodomy. It would not have also been aggravated sexual battery. And those are the three
things. Had she made
things.
those allegations, so it's close.
But as we know, what the allegations that were made are important, and those three things were not the allegations that were made. They were not even close to any of those three aspects of it. I would also disagree when we say there's no corroborating evidence. When you say there's no confession, there's nothing saying that those things would not take place. I mean, there would have to be some type of corroborating evidence to bring the case. Like in any particular case, there's going to have to be some type of corroborating evidence
Does this say
that will exist. No, it does not say that, but of course it doesn't necessarily say that in any particular case. We don't lay out what all the evidence is going to be. The evidence is what it is. If we tried to do that, which I understand, if we tried to do that, we'd only be guessing. And if we did that and then we missed a particular piece of corroborating evidence, then the person would still be precluded. And especially today, we'd almost be guessing of what could take place 15 years from now as far as what could be corroboration to some extent. And we don't know what those things could be, especially with technology. We just have no idea. So we would only be guessing at that if we tried to list out. And I would say that that actually is unlike any other thing that we would do to try to list out all our corroborating type evidence that you may have in a crime. We don't do that with any crime. We just say what the elements are, and the elements of rape are forcing against a person's will and against a female. Those are the elements of it. From there, you have evidence which goes into that.
But in all those other ones, you have to bring them within 4 years when the defendant has the opportunity to get corroborating evidence to say where they were, other people that might have been there. It's so difficult to do 25, 30, 50 years after the alleged crime, right?
And I would say that if that's the case, then the prosecution would not go forward. That would be my argument. I would think that the prosecution would not go forward. And I would say that to place that line on this particular type of case, because there's so many reasons that a woman, most women, of course, the other two offenses could actually apply to men. To place that line where there are certain circumstances where a person may not come forward. For instance, last week when we heard that testimony, she very well may have not come forward if that was a rape case because that was her coach, because that was somebody that maybe her father knew and trusted. And that's exactly the reason why she may not have come forward. But guess what? She still would have had to have evidence. To say that she would not have had to have evidence, I think goes into the face of what exists today. We would assume today that people are just prosecuting people with no evidence in situations of rape and aggravated sodomy and aggravated sexual battery. I say that those cases are looked at very, very closely now, and they're even going to be looked at even more closely as that time period has elapsed.
Okay. Can I ask one more question, Mr. Chairman? All right, so your example of the young girl, I get that. I mean, those of us that have daughters certainly want to protect them, but at line 25 and 26, the existing law already provides that if somebody's under 18 years of age when the attack occurs, then they have 7 years after they turn 18 for the prosecution, right? So we've already extended the statute of limitations 7 years beyond when a person turns 18 if they were a minor when they were victimized, and we've extended it really forever if there's DNA evidence already.
That's correct.
Right? Okay.
That's correct,
All
Mr.
right.
Chair.
Thank you.
Senator Kennedy.
Thank you, Mr. Chairman. Senator, as Senator Calster said, I applaud the efforts of, I think, what you're trying to accomplish, but I want to make sure that I understand, because I think you and Senator Calster have experience in the criminal process that I don't from a practice standpoint. And so I just want to make sure I understand the net of your conversation with Senator Calster. Would it be that when you said there would still have to be corroborating evidence for the case to be brought, but couldn't the case be brought if the statute were changed based only on the testimony of the victim? And for example, 50 years after the act or the alleged act, wouldn't that be the only corroborating evidence that would be necessary for a prosecutor to bring the case if they chose to do so?
Will be the testimony of the alleged victim.
Yes.
I would say that actually exists even today on many cases where the only corroborating evidence is the testimony of the alleged victim. But I mean, in the sense that you have to deal with this from the standpoint of judging the veracity of the person who's coming forward, and based on all the totality of the circumstances. We could go into 100 examples about how those totality of circumstances are reached as a prosecutor, whether we're dealing with just a simple battery case, a domestic violence case, or whatever type of case it may be. A person comes to you and says somebody punches you. The other person says they didn't. I mean, when you're a misdemeanor prosecutor, that's exactly what you're dealing with. You have to make those decisions based on whatever those surrounding circumstances are. In cases go to trial like that, the surrounding circumstances are going to exist. It's almost impossible to go through every single scenario what those circumstances may be, and at that point in time, we're just guessing at what they are. But I guess I could just say that from a prosecution standpoint, if you're doing your standpoint from a prosecutor the way you should, and you're seeking the truth and you're seeking justice, you're going to make sure that you actually have a case that can go forward. To suggest that you have prosecutors today or later that would just go forward on a case without whatever those corroborating circumstances are is just not accurate. Especially even today. And I think it was telling when the prosecutor last week even said himself, I thought this might be a mistake. There's no way a coach would do that. Even he came in with skepticism. To say that skepticism would somehow disappear 15 years later, it doesn't make any sense. To say, well, now all of a sudden he's skeptical now, but that skepticism won't rise 15 years later to where he or she would look at that case even more closely. Not that they're going to look at it less closely. And I think for some reason we're having this difficulty juggling this to understand that it's already a tough case to bring. Any of these sexual assault cases are, and that difficulty will go away. And now that a prosecutor would just run to the courthouse based on nothing else than someone said something, when they don't do that necessarily today. Most victims would tell you today they have difficulties. To think that goes away, I just don't understand why we have that conversation and we believe that would be the case. And I think that's exactly what it is that belief that for some reason that everything that goes into prosecuting a case would go out the window 15 years later. And that's all I can say is that's just a belief. I don't know if it's based on any real. I don't think it's based on anything. It's just a belief that all of a sudden somebody will be out to get somebody 15 years later, where today they're looking at these things with a jaundiced eye as it is.
And Senator, I appreciate that. It's not a matter of thinking all those things go away, I don't think. And certainly I understand a lot of prosecutors have difficult cases where, as you alluded to, the only evidence is the evidence of the victim, the testimony of the victim, and that's countered by the testimony of the defendant. But I think the issue that we're discussing is not the suggestion that all that goes away. There's a reason that statute of limitations exists in jurisprudence, and it is because of the availability of evidence, the value of evidence, other issues that come to play with the passage of time. And I think that's maybe at the heart of this. It's not somehow a belief that the questions are not sourced from a belief that prosecutors are somehow going to behave differently or improperly if this is changed. So I want to make sure my questions are clear with that from that standpoint. It is more a recognition and making sure that we remember the due process issues that are inherent in statute of limitations.
That's correct, but we also have to have the balancing test under the circumstances of why in these particular sort of cases persons would not come forward. And I think that's what we're looking at, and it's totally different than almost any other case that exists of why a person would not come forward in these particular type of cases in that time period.
Which would be currently 15 years? Is that what the statute?
That'd be correct. Currently. Which, as I've stated, we have eliminated on 2 other situations. Remember, even with DNA, you still are stuck with that issue of consent. That is the issue. You're still stuck with that issue of consent. That doesn't go away. The reason why we have the DNA, let me tell you how DNA is being used now, and I'm not sure if it's being used this way in Georgia, but across other states are. I think we have this notion of the DNA hit being we got the serial rapist who's in jail. So we know he must have did it because we get the DNA hit, the person charged with a felony, we get the DNA hit, it's a serial rapist, okay, we know he got him. He had to have done it. But that's not how DNA is necessarily going to be used in the future. I believe it's California that actually may be now going to where you can go onto these ancestry sites, get a subpoena, get DNA off of that. Well, that's just your regular person. It's not necessarily the felony hit with the guy with a bunch of tattoos in jail. That certainly is going to still, without a doubt, have the issue of consent. That's just going to be your regular guy. You go to Ancestry.com or whatever it is, get the DNA. I think our way we're looking at it would totally change. Right now, our mentality, because that's kind of like what we've developed, has been DNA, serial rapist in jail, felony charge, we got him. I think that's maybe going to change when we start saying, oh, it's just DNA off Match.com or Ancestry.com. The guy's a lawyer or a doctor. Now do we have him? The consent issue would definitely be a play there, without a doubt. And that would not go away. So mentally, we think the consent issue is gone because we got the guy with a bunch of tattoos and he's done 5 other rapes. But now if we get to the point where we go to Ancestry.com and we have the doctor, the lawyer, Kavanaugh, I wonder if we're going to have the same kind of opinion that we automatically got our guy. Consent is definitely going to be an issue at that time, and we've eliminated that DNA requirement here in Georgia.
Senator Jones, one other question on the drafting, line 27, should that also be subsection B there as well instead of subsection A?
You know, I'm looking at the amendment also, Mr. Chair, to make sure that we're on the. If I may have a little bit of help
Yes.
here, Mr. Chair.
Please. Has Prosecuting Attorneys Council seen this draft of the bill as well?
I haven't seen a copy of the substitute.
Okay.
Thank you.
Let me get you
I
back.
have a
up.
mistake on the amendment there, Mr. Chair. To where on line 15, it should say subsection B, correct? And on line 27, also subsection B. He must have liked it. He'd be here otherwise.
And also on lines 18, 19, and 20, you're going to strike everything, semicolon after section and everything beyond that, put a period there instead?
Yes, I believe so. Yeah, I see. Yeah, definitely. Is that correct? Is that correct?
I think what she might be telling you got to think about crimes committed prior to July 1st, and so you might want to put the same caveat there. On except as otherwise provided.
On striking that line, Mr. Chair, it brought my attention that what would happen on crimes committed before June 30th if we struck it.
Right.
So to keep it in.
Why don't we do this? Why don't we hold on the bill until later in the committee? We'll probably take a break in a minute anyway, and make sure that Prosecuting Attorneys Council is comfortable with the final version and we're all clear what it's going to look like. If we can get that done today, we can vote on this now versus wait until tomorrow. But I just want to make sure we start doing this stuff on the fly.
Right.
We may make a scrivener's error. We've heard about a few times.
Yes.
Any other questions for Senator Jones before we hold on this? Okay. We'll come back to Senate Bill 18. Do you have anything else? Okay. All right, we're going to move on to Senate Bill 160. Back on the agenda. And we are working off LC 364638. Senator Cowsert.
Thank you, Mr. Chairman. I'll present from here if that's acceptable to the chair. I have a series of 3 bills that are all probably familiar topics with most of you in the room by this time. Each of these was included in the tort reform package last year that was tabled and due to the pandemic never got a vote in the state Senate. They are simpler than dealing with an omnibus bill, just to try to have bite-sized pieces of ideas to help level the playing field for defendants in the state of Georgia. Our members here have been passed out a publication by a admittedly biased group, the Americans for Tort Reform, that reviews the judicial climate in each state, and Georgia now for several years has been included in their list of judicial hellholes. That definition is the identification of documented places where judges in civil cases systematically apply laws and court procedures in an unfair and unbalanced manner, generally to the disadvantage of defendants. That is the reputation that our state is rapidly gaining. We're up to the number 6th state on this list, and I suggest that some of you take a look at this and read it. I've practiced in the civil sphere for 37 years now in Georgia and tried pretty close to 500 civil trials in my career, and I have seen the rules, the procedures that we as the legislature have put in place tend to support the plaintiff's cases every time to the disadvantage of the defendant. And this isn't something that helps me financially. Probably the tougher the rules are against the defendant, the more cases I would get to have to defend. If you looked at it that way, I do work on an hourly basis. I don't get paid on a percentage, and so there's no incentive for me to have any kind of financial benefit. But I've been looking at the big picture, and I think that the just public perception now, certainly the business community's perception of the rules of evidence, the rules of procedure, the climate here in Georgia is that this is a very dangerous place to do business because of the susceptibility to lawsuits with tremendous verdicts against you, and this frustrating feeling on many of those folks' part that they're not getting a fair shake, and that's something that I hope to correct. These 3 bills I have are sort of sequentially, they're very minor fixes. Certainly the first 2, the third one gets a little more substantive. So I would ask that people be open-minded to let's try to in some way decide, does this little rule really make that much difference to the plaintiff's bar, or does it create a more level playing field and more certainty from the defense perspective? One thing that we have developed over the years is exceedingly high automobile insurance rates, liability insurance rates, which we mandate by law. You're required to have it to operate a vehicle in the state. Our rates are extremely high compared to other states, some of the highest in the nation, and it's not just because Georgia has a bunch of dumb, bad drivers causing wrecks. Our drivers are no worse than anybody else. Our road system is better than most other states, and particularly now with the decrease in traffic from COVID. It's because of these rules and these regulations. So Senate Bill 160 deals with the very simple rule. We just talked about it in the criminal system, the statute of limitations, the length of time you can bring criminal charges against a criminal. In the civil world, we have the same type of rules, limitations, the number of years from the date of your injury that you have to bring the lawsuit. In Georgia, for many, many years, you had 2 years from the date of your injury to bring a lawsuit against the at-fault party. for personal injury or for wrongful death. We have a 4-year statute of limitations if it's a property damage claim. Well, we passed a Crime Victims Protection Act some years back, and it was intended to protect crime victims, give them an opportunity to bring their suits, to extend the length of time they could bring their cases. And that's what this bill addresses in Code Sections 9399. This law allowed you, for any victim of a crime, any type of crime, to bring the suit from the whenever the prosecution had been completed. So your time period began where the injury occurred or whatever, and it was extended beyond the 2-year period up until the prosecution of the crime had become final. So the trial was over, but no longer than 6 years. So there was a cap. It couldn't go longer than 6 years. Now, that made an awful lot of sense if somebody was a rape victim in an apartment complex. They didn't know who the perpetrator was, so you didn't know who to sue for that type of event until the criminal investigation and prosecution was included. But the statute was written so broadly that any crime includes misdemeanors and simple traffic offenses like following too closely, failure to maintain a lane, speeding, any of those type of charges that you receive as citations are criminal acts. And so what we inadvertently did on very minor criminal acts that create a civil cause of action, we've extended or told our statute of limitations for up to 6 years. In doing that, the people that are handling risk management, and it might be self-retention funds for certain trucking companies or business, it might be an insurance company where you have insurance, they have to set aside reserves to take into account any potential known risks. And you do that by figuring what's the likelihood you're insured or your business is liable, and then what's the potential exposure on the damages, what are the claimed injuries that are known to you at that time. This is one thing that's helping drive up the cost of insurance when companies are having to set aside reserves for potential claims for indefinite periods of time. So the underwriters are befuddled as trying to figure out how much money do we have to set aside and how long do we have to do it. Well, that's coming out of your premium dollars. So back to the John Doe situation. You know, in these property crimes or other violent type crimes, if you don't know the perpetrator, it might make some sense for you to have an extra length of time for that to be determined, especially if there's a criminal investigation. In these automobile collision cases, you know, there's rarely any doubt as to who the identity of the drivers are. They're taken down on the accident report with their name, their driver's license number, their address, their phone numbers. They are easily identifiable. There are some circumstances where there might be a hit and run driver, or there might be a John Doe vehicle that they didn't stop at the scene. You don't know who they are, so you can't identify them. But unlike these other criminal incidents in the automobile collision sphere, you have ability to recover against a John Doe driver from your own insurance company, from your uninsured motorist coverage, and it's quite common to sue a John Doe driver, so you don't have to know their identity to get your justice, to get your relief, to get compensation in court. So those arguments don't apply in these misdemeanor criminal traffic offenses. So all this code section does is change the current tolling provision to apply only to felonies, to serious offenses, so that it would not apply to misdemeanor criminal offenses to toll the statute of limitations. And so that's all we do. You just see where it strikes through crime, which includes misdemeanors and felonies, which are serious crimes, and it just substitutes felony in those two places. I would also point out that, you know, in a civil case, you don't have to prove that the person, I mean, you don't have to have a convicted criminal to prove your case. It's a higher standard of proof in a criminal case. It's beyond a reasonable doubt. In a civil case, it's just by the preponderance of the evidence. So whether or not there was a criminal prosecution in no way bars you from bringing a civil case, and it's not dispositive one way or the other. Now, if somebody pleads guilty to a criminal offense or pays their fine, forfeits their bond, then that can be deemed an admission against interest. But it is not required. for you to do that. I mean, many times we argue in cases that it's really not even relevant if you received a ticket in the case. We bar that from evidence because that's the hearsay opinion of the police officer. So it's just not an important factor in getting justice in the civil process. And I think this will reel it in a little bit, and I don't see where this is should be anything particularly controversial. I think it was an oversight, an unintended consequence in the draftsmanship of the victim Bill of Rights back in the day when that was done. I want to say it was 2005. I actually brought my code with me today to look it up if I need to, and I have that with me so we could verify. This is all in just one little tiny one paragraph code section 9-3-99. Looks like it was enacted by Georgia laws of 2005. Seems like it was the last time we've looked at it. So that's all I think we need to know. I'll answer any questions folks might have.
I have a couple initial questions. How is a conviction, whether that be a plea or finding of guilt, used in a civil case generally?
In a civil case, a conviction is not admissible.
Okay.
A plea of guilty is as an admission against interest.
Okay. So to the next part of that question then, and there are certain misdemeanors that, in my limited criminal experience, I found some things were surprising that they're still a misdemeanor, such as some battery, family violence charges, and of course DUI, vehicular homicide. Is the right line to go on this, if we're looking at the seriousness of the offense, is felony the right way to go, or do we need to carve out certain misdemeanors as well that may be as serious as felonies?
Well, first of all, vehicular homicide is a felony.
There's a misdemeanor version of it too.
Serious injury by vehicle or something like that. Well, in my view, since that the outcome of that prosecution does not affect the evidentiary burdens or the rulings in a civil case, that it wouldn't need to be included. I wouldn't have an objection if you wanted to include DUI, but I mean, I've defended quite a few cases where the defendant is accused of having been intoxicated or impaired at the time of the accident and weren't even charged. So that is in no way dispositive. If somebody smelled like alcohol at the scene, or somebody said they saw him drinking in a bar earlier, etc., it bolsters your case to have a plea to that, but to have a conviction for the DUI is not admissible in court.
So just the plea is what would come in, but not if you're waiting for a trial itself.
Right.
Okay. Senator Hatchett.
Yeah, Senator Cowsert, I was going to ask about if a felony gets pleaded down to a misdemeanor, how would that affect this?
If it gets pleaded down
to a misdemeanor, but it happened 2 years later.
Let me look and see the wording. I wonder if it's the, whatever the victim would allege the crime had been, but this reference is a prosecution. So if you're prosecuted charged with the felony, then I would think that would be enough to toll it until the conclusion of it.
Okay.
Because that's the way this reads.
Mr. Chairman, if I can ask one or a couple follow-up questions too. One of the issues that I know occur in civil cases when someone's charged with, I'll just use the misdemeanor vehicular homicide, is that there's there's always the option that the defendant in the civil case would plead the fifth until the conclusion of their criminal case. And if it's a misdemeanor vehicular homicide where fault is questioned, I'm afraid that this would discourage openness from the defendant and would prevent any type of, a good deposition where you could ask questions where they would be open about where they were driving, because they would just plead the fifth to protect themselves in the criminal cases. Have you thought about the exception for that?
Yeah, well, that's covered by our current rules of civil procedure, I guess, or rules of evidence. If you plead the Fifth Amendment in a civil case, there is a presumption that the question was accurate. So it does the criminal defendant no benefit. In fact, it does them harm in the civil case. If you're suing my client, they're accused of DUI, and you ask them, were you driving under the influence, and they say, I refuse to answer that question on the grounds it might incriminate me, then the presumption is, and the jury is told that presumption, is that I am guilty of it.
Right.
It's just not used against me in the criminal case. So really the fact that these are told, these limitations, extends the time that they might be pleading the Fifth Amendment. But you would not be harmed by that as an injured person in a civil case, because you then have the presumption that they did whatever the question was that you asked, that they raised that, Fifth Amendment defense. That makes sense? You might have had it come up, or you will one day.
I'm okay with this. Yep.
One other question can be think of. So I guess the other potential benefit of the current law is getting a copy of the file from the state that's prosecuting the case. Is there any?
Yeah, I think. Yeah, I'm sorry.
Well, like, the question is that another benefit of waiting until a case is concluded so you can actually get the file? And if so, is there any way that benefits both sides of a civil matter if the whole matter can be concluded first?
I think that may have been part of the thinking, is the investigative file during particularly in a felony case may not be known. There is no file in a car wreck case. The file is the accident report. The ticket has already been issued. That is the investigation is there at the scene, and they issue the citation, which is what would be tolling this on the spot, and it's in the accident report, and those are not sealed or confidential or
I guess I'm thinking beyond the car accident, which is probably 99% of what we're dealing with, but I'm thinking, again, like to a battery case. I'm not sure how many civil battery cases there are, but if it's a misdemeanor one, if there is any benefit to having access to that file like you would with some felonies. But
I can't think of a circumstance where that, in a misdemeanor stance, that would apply.
Okay. Any other questions for the author of the bill? We have, I believe, just one person signed up to speak on the bill. Jonathan Pope with the Georgia Trial Lawyers Association.
Good morning, Mr. Chairman and members of the committee. My name is John Pope. I'm President-elect of the Georgia Trial Lawyers Association. I am here this morning to speak in opposition to Senate Bill 160. Some of the arguments have already come up in the discussion, so I'll try to be brief. The bottom line is this bill will change current law that allows the time limit to file a lawsuit in cases where the defendant, the wrongdoer, violates a law. It's going to change it to limit it just to felonies, as has been explained. I think, as Senator Counselor mentioned, that this is, in his opinion, a kind of a minor change. I would respectfully disagree, because to be clear, this is restricting and limiting rights that Georgia citizens currently have, is reducing the amount of time they have to file a lawsuit. And so I think anytime we're going to limit our citizens' rights, I think that's a pretty important thing. And I think our main issue with this bill is again, as some have mentioned, is we believe it's really going to result in the filing of more lawsuits. And what do I mean by that? Let me explain. Under the current law, a potential attorney or plaintiff has time to, after a criminal proceeding to complete, to get investigative materials. And I would argue there's more than just the accident report in misdemeanor cases. You can do open records requests and obtain information like photographs. Many law enforcement now are photographing vehicles, the scene of the accident. They're videotaping it. They have body cam, dash cam, audio and video. A lot of material that can really help the plaintiff and the attorney investigate the claim, the basis of the claim, the merits of the claim. And that would be restricted if this law were enacted. That extra time can result in a determination of this is not a claim that has merit, and we don't need to bring it. Two, it can result in the ability to resolve the case prior to the filing of a lawsuit, which is always the best situation. If this bill were enacted, you know, think about how that would affect a case in a most common as Senator Counselor mentioned, a motor vehicle collision case. You know, criminal investigations can take several years. And during that time, while a criminal investigation is pending, the Open Records request, the Open Records Act in Georgia doesn't apply. There's not an exception to it. So what does that mean? That means we're not able to, the plaintiff and their attorney are not able to get the investigative materials from the law enforcement, from the prosecutor. And therefore, that really prevents a full investigation of the claim. If the statute does not continue to be told as it is now, then in many cases be forced to file a lawsuit to preserve our client's rights. And again, that obviously resulting in more lawsuits. You know, filing suit, it was mentioned as well, filing suit while there's an ongoing criminal proceeding is really problematic, not only for the plaintiff, but also for the defendant, the wrongdoer. You know, as was mentioned, in response to discovery, the part of the litigation where parties find out information about the claims and about the other parties, the defendant will, if the criminal investigation is ongoing, the criminal or the defendant is going to plead the fifth, and that information that's not going to be able to be obtained. So in addition, you're going to have the defendant, the wrongdoer, is going to be defending not only the criminal investigation, but also the civil lawsuit. So there is an issue there. We would respectfully argue that this is really kind of a situation where it's a solution in search of a problem. And we don't think that Georgia, the rights of Georgia citizens in this regard need to be restricted. So thank you for your time. I'm happy to answer any questions.
One question. The main purpose of the bill, according to Senator Counselor, really is to deal with the issue of the time you have to wait on these matters to see, you know, for insurance companies, for example, and trying to value what something's going to cost. How long does it normally take to get, in your experience, a resolution of a misdemeanor versus a felony? How long normally does it take for a misdemeanor case like you deal with to go through court?
We're talking about things like the things that Senator Counselor and I see, and y'all see as well: following too close, too fast for conditions, running a red light. Those are, you know, misdemeanor traffic citations. Those are resolved fairly quickly. I would say definitely 6 months, generally no more than a year.
Is he correct in that in those kind of cases, the only thing in the file is basically a police report?
Well, I mentioned that earlier. And again, you know, Mr. Counselor's an excellent defense lawyer, but as a plaintiff's attorney, it is standard. I would say it's almost the you know, the standard of care for an attorney, a plaintiff's attorney, is to request things like the body cam video, which obviously shows what the officer is looking at and seeing, but it also has that audio, which is almost just as important as the video. The dash cam, I always kind of laugh about it because most of the time you can have a 20-minute video of a dash cam, the police car is parked out, you know, and you don't see anything, but the audio is attached to the police officer, so you can hear conversations between the officer and the parties involved in the collision, and that's very important. Again, I mentioned also things like the skirt teams. They have a lot of information. If there's an accident that the Georgia State Patrol skirt team investigates, it can be measurements, data from vehicles, things like that. And again, none of that is accessible by an open records request while a criminal investigation is ongoing. I hope that answered the question.
Senator Hatchett.
Hey, thank you, Mr. Chairman. I have just one quick question about an argument was made earlier that delays in the judicial process due to the statute of limitations are why our insurance rates are increasing in Georgia. I was wondering if you had any information about how much our insurance rates have increased since this delay in the judicial system due to COVID.
Well, you know, interestingly, I got an email from an Allstate agent in Canton Friday indicating Allstate's rates are going down, and last year State Farm, this is public record, reduced auto rates in Georgia by, I want to say, close to 13%. So I'm a little, you know, again, maybe I don't see that auto insurance rates are going up. and I don't think this is a problem. I will say, as a practicing attorney for 25 years, this statute has resulted in less lawsuits by giving the parties time to properly investigate and try to resolve cases, and that is my experience.
Thank you.
Any other questions for Mr. Pope? All right, thank you.
Okay, I'll be back, I'm afraid.
I'm afraid so too. Nobody else signed up to be heard on the bill. Senator Calvert?
Just as a final close.
Yeah, I'll give you the last word.
The way you phrased something, that my primary motivation was to lower insurance rates or whatever, it's really to have a level playing field in the same way that a defendant in a criminal case has to present evidence to keep from going to jail. A defendant in a car wreck case has to present evidence too. And so if you're waiting 6 years after the wreck to even file the suit and another couple of years after that to be presenting evidence, how are you going to find your passenger in your car or the people in the other vehicles that might be witnesses for you? So this is also to give these defendants an opportunity to provide an adequate defense, and the longer you wait from the date of an accident, the staler or the more difficult it is to find your evidence. From a plaintiff standpoint, their state, South Carolina, it's a 1-year statute of limitations. You know what your cause of action is. Who was at fault in the collision? Sometimes it makes sense to wait a little while to see if your person has any injuries. But within 2 years, you know what happened in the wreck, and you know whether your person was injured. And even if they're having future problems or may need surgery in the future, we provide compensation for your already incurred losses and expenses, as well as any future medical expenses that you can prove. So it's just really, it's not a compelling argument that you need more than 2 years to make up your mind whether or not to file a civil lawsuit.
All right. Anybody else signed to be heard on the bill? What's the pleasure of the committee?
Motion to pass.
We have a motion to pass by Senator Kennedy. Do we have a second? A second by Senator Kirkpatrick. Any discussion? All those in favor of the motion, please raise your hand. We have 4. All opposed? We have 4. The motion fails. Let's take a 5-minute break, and then we'll come back and move on to the next bill on the agenda. because of scheduling, we're once again going to go off the agenda for one other bill before we go back to Senate Bill 189. We're going to hear Senate Bill 164. Senator Hufstetler. Thank you.
This bill
Before
actually.
you get started, which LC are you working off of?
Okay, I've got LC 338615.
All right, let me give 1 second for us to get to that part of our folder, at least for me. Okay, you said 338615?
Correct.
All right, the floor is yours. Thank you.
All right, and as I was saying, the bill in this present form passed out of the House last year due to COVID and priorities. It didn't make it over to the committee in the Senate. And I don't know of any opposition on this. There are several people signed up to speak in support of it, but they also said they some of them could waive if need be, if the testimony wasn't needed. But this is a modernization of the bill. Some of this goes back to the 1980s when HIV and AIDS were used interchangeably. Human immunodeficiency virus is a virus you get. AIDS, acquired immunodeficiency syndrome, is what you can get from it. And it also changes some things for the prosecuted attorneys that they want. It takes the syringes out of it. We've changed that nationwide and statewide, and we've had bills here that have syringe exchange programs that deal with that. So I can quickly go through some of the changes, and I should have added the Department of Community Health wants this as well. Section 1, the thing of substance, is lines 16 and 17, clarifies in the Juvenile Code section that the Department of Community Health does not approve HIV tests. That's the change there. And then in section, well, I guess I'll just go ahead and say section 3, 4, and 5, you'll see a bunch of changes, but it all has to do with, and 6.2 actually, changes with hypodermic needles and syringes, that we no longer look at them in a criminal method because science says it's not practical to do it that way. And then section 7 is just again clarifying on lines 189 and 190 that the Department of Community Health does not approve HIV tests. So that leaves section 2. Some of the things of substance there, lines 42 and 43 clarify that a person who is living with HIV and is a victim of a sexual assault can't be charged with a crime. We've actually had instances where someone was raped and didn't report it for fear of being prosecuted, the fact that she was living with HIV. Section 60 to 63 is acknowledgement of the HOPE Act, which allows HIV organ donation to other HIV carrying people who know the status and are willing to accept that. And I think there's been at least 100 of those donations that I know of. Line 64 and 65 maintains the felony punishment scheme, but reduces it to no more than 5 years, in line with Governor Dill's criminal justice reform. And then on line 66 to 77 are really deleted because the recent Back the Badge legislation adopted by the General Assembly ensures, that a battery against a correctional law officer was a felony, and so this is really redundant and potentially, language that may not be in conformity with it. So again, the Department of Community Health wants to be acknowledged that they don't approve tests; they never have. Syringes are taken out as being drug-related objects, and then the clarification of whether there's criminal intent or simply negligence in line with the law and in line with the Back the Badge law. With that, I should have said, like Senator Beach, I'm few and far between coming to this committee, and it only reinforces being here today that I want to continue that.
I have a question.
All right.
When I first read the bill, and I talked to you about this offline, my first takeaway was it looked like we were adding this new intent to transmit HIV where in the past it seems like the way it was written, it was more of just if you perform these acts, it was almost like, I guess, assumed you had that intent. Can you address that change in the bill, or if not, one of the other people?
Right. According to the prosecuting attorneys, and my understanding is that we don't criminalize negligence, that this would be in conformity with current laws, that if there's an intent to do this, that would be what's currently looked at. And again, you guys know more about that than I do, but that's
so it's
my
safe to say
understanding.
that's more of a of cleaning up and restating the current process in the law versus any substantive change when we add with the intent in the bill.
That's my understanding, correct.
Okay. Any questions for the author? And you mentioned some of the people that wanted to speak on the bill. They all indicated they were in favor of it, from reading it correctly. If you want to be heard still, I'll call upon you. If not, you also always have the right to waive. We have Maisie Lynn Causey with Gactyl.
Unless you have any questions, I can wait.
Does anybody have any questions they'd like to ask Ms. Causey? Thank you. And Kathleen, is it Tahan? Tahan. All right. Anybody have any questions for her? She's with the Georgia AIDS Coalition in favor of the bill. Any questions for her? Okay. Thank you. All right. What's the pleasure of the committee? We have a motion to pass by Senator Parent. Do we have a second? A second by Senator Hatchett. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? It passed unanimously.
Thank you, Mr. Chairman, and my witnesses. We're trying to be respectful of your time, so I appreciate your passage of this.
And I appreciate that, and I appreciate you all being here to support the bill in case there are any issues. I appreciate your work on this. All right, going back to the agenda, we are back on Senate Bill 189, and we have a substitute for consideration, LC 364726S. Senator Cowser.
Thank you, Mr. Chairman. This is another effort to level the playing field in the civil practice and trials in Georgia. We have been shocked by some of the humongous verdict sizes on various tort cases here in Georgia over the last several years. That's one of the factors listed in the judicial hellhole report. Some just almost defy reason. And one of the motivating factors for these large verdicts are the horrendous nature of the damages. I mean, some of them are death cases. Some of them are where a person is shot in a parking lot and a robbery gone awry or whatever and end up paralyzed or have permanent disabling injuries. Those type of injuries create tremendous sympathy from a jury, and they mostly occur in cases where there's something that takes a lot of medical expenses or greatly limits a person's activities. Sometimes if a baby is born and there's a medical malpractice alleged and the child has some type of brain damage or birth defects or whatever, this really plays on the sympathy of the juries and sometimes clouds their impartiality on the issue of damages. Georgia law, we're looking at a code section here that is already in Georgia law. It's Section 91142 of the Civil Practice Act, which allows judges to bifurcate or split the trial of issues, any claim, cross-claim, counterclaim, third-party claim, or to separate any issues or number of claims in a case. We see this already a lot. It's done in punitive damages cases. Say, we were talking about some cases earlier about a DUI defendant where the plaintiff is seeking punitive damages. There's a first phase of the trial where they decide liability and decide if it is a case that warrants the imposition of punitive damages. Then the verdict is rendered for compensatory damages for whatever the injuries the person received in the wreck. And then the jury reconvenes, same jury, and takes up the issue of punitive damages, how much, if any, punitive damages to award against the bad actor defendant that was drunk at the time, or whatever actions they might have taken that were so egregious to warrant punitive damages. And by doing that, you don't mix the issues and don't make the jury too biased against the defendant in awarding damages and unfairly inflate that end of the case. This is just to extend that principle and make it more prevalent in jury trials. And as COVID's come about, it really is something that we think will expedite and economize the trial system, because there'll be some cases that will terminate after the phase deciding the liability issues and save 2 or 3 days of trial, so these other backed up cases can be reached. Sometimes it may go the other way, that it might be the liability is in dispute, and once liability is determined against the defendant, the parties quickly negotiate. That has happened to me on occasion, where there was a legitimate dispute as to fault, but if that's rendered against your client, well, then it's very clear what the damages are, and you start negotiating a whole lot quicker and more seriously at that point. So it can cut either ways, but basically divide the length of the trial, maybe even cut it in half or more on some of these cases. So what this bill does is simply it sets up 2 circumstances where the courts can bifurcate. On line 17, it says that if there's that 17 to 20, if it's a tort case, not a case, but a case for personal injuries or wrongful death or other type of negligence claims, if you're asking for over $150,000 in damages and there is a liability dispute in the case, then the court will separate it up into the 2 different trials, unless for good cause shown they decide it ought to be just one trial. So it's still an ability of the judge there, but it's a presumption that it should be split in those big damages cases. Starting in the subparagraph 3 on line 21, in other tort cases, if you're asking for less than $150,000 or less, then it just lists the factors that the judge should take into consideration in making their ruling as to whether or not to bifurcate or split the trial into 2 separate trials. Now, it really is one trial. It's just a continuum, as you see there down on line 34 to 38 at the end. You don't put in evidence on the damages until you first determine the issue of fault, of liability. The same trier of fact, which could be the judge or it could be a jury in fault, will hear both of these, and the second trial begins immediately after the completion of the first trial. So it's not like we're having to go select a whole new jury, start a brand new trial, and drag this out. It's just seamless. It goes right in immediately after the first issue is decided. A couple of the issues that are considered by the judge are on lines 28 and lines 30 are evidence relevant to damages. If it has a prejudicial impact on the determination of liability, that's a good reason to save it for a separate trial. Or if the evidence relevant to damages poses a substantial risk of impairing the objectivity of the jury on the liability issues. This is to give the jury, keep them from being unduly biased by the nature of the injuries on the liability question. But now you also see there on line 34 that if the party opposing bifurcation would be prejudiced if it's granted, then the court would not be able to do that. And then again, so if the issues to be bifurcated are too intertwined together, or too mixed together, then the judge wouldn't have to bifurcate those issues. So it just sets up kind of a 2-tier system that if it's a very significant case with over $150,000 in damages, unless the judge can show good cause that it should be a single trial, he should bifurcate. In all other cases, $150,000 or less, we list the factors that should be considered by the judge before rendering that decision whether or not to bifurcate. And I think that's as simple as I can make it.
I have a couple questions, and we were talking offline about whether or not this would apply to other types of cases outside of torts. And it seems like generally the current standard would remain in place with the exception of or adding to expedite and economize on lines 12 and 13, and also what the judge will consider as far as the merits of each case on lines 15 and 16. So that section would apply to any type of case, but everything else just applies to torts.
That's correct. Yeah, so I'm not changing the underlying law on cases other than tort cases.
Except what we did on lines 12 and 13.
Right, to expedite or economize.
And on that note, I did not ask you this question, so you may not have looked this up. But I did ask some of the folks that were going to testify today, so I'll go ahead and ask it now. This is current law, what's obviously in lines 12 through 16, with the exception of what we discussed. And so currently, someone can make a motion to have separate trials in furtherance of convenience or to avoid prejudice under the current law. The question I have is, has there been a standard set up by our courts when considering those motions now? Is there some way the courts now weigh that based on case laws? It's pretty general what it says. And obviously what you're doing in fairness is adding more direct lines of what a short court could consider. But is that consistent with how that's been interpreted now?
Yeah, I'm not familiar with any court law that has set forth the factors they should consider. And so that's all this is doing, is let's give the courts guidance on what factors to take into account and before making that ruling that they're already allowed to make.
And another question I have is for people that do plaintiffs or defendants work, or generally that have tried to use this code section, I guess you would probably have to research what the standard is. And so is this being used now? Is there a reason judges are not allowing this to go forward in some of these cases now? What's the current state of this? Do you know?
I have attempted on several occasions with no success because it's purely within the judge's discretion. And in my case, I guess I hadn't been very persuasive. I even recently tried to trifurcate a trial that did have punitives, but I wanted to separate the liability and then the damages, and then let's deal with punitives, and that did not meet with a very warm response.
And last thing, then I'll let other people ask questions. A big part of doing this is also to expedite the process and have hopefully shorter trials, is the way it was said to me. That
is the hope, and that it makes sense that it would, because
we address that, because I was wondering how it would not make it take longer if you have to start over again.
Because if you're combining the issue of damages and liability, it's going to take longer to present all your proof. And if at the end of the jury's deliberations they find in favor of the defendant, then they just wasted 2 or 3 days hearing about damages that they didn't even need to concern themselves with. If they, let's say it's a medical malpractice case and they're looking at the standard of care of the doctor, and they determine, well, the doctor did what ordinarily prudent doctor would have done under the circumstances, well, then the case is over. You don't need to go into all the injuries and the treatment needed in the future and the potential of future surgeries, et cetera. All that evidence would never have to be heard. On the other hand, I mean, the jury makes their decision, and then you just continue the trial. It's the same length of time it would have taken to hear the damages evidence afterwards. At midpoint, basically, of the trial, you determine the liability issue. Now, I use medical malpractice as an example because the damages can be so extensive there in the future treatment, et cetera. The same thing for a catastrophic injury case, like I was talking about the shooting where somebody's paralyzed and needs a life care plan. That takes a lot of evidence to prove that you would never have to present if the liability issue was found in favor of the defendant. And I think the corollary, the contrary is also applicable. If they were found guilty, well, then they're going to sit down and seriously talk settlement right then before they commence the second section of the trial.
And you mentioned the only other place in the code I know where we do this automatically is with punitive damages, and I actually have tried that.
Right.
And the reason it's done though is because after someone has been found liable for punitive damage, the issue becomes how much does it take to punish them. So the separate trial is actually a whole different issue of that person's assets, stuff that obviously would not be admissible in the underlying suit. So I have addressed that before, but it's different because you have two different issues completely at hand. Any questions for the author of the bill? Senator Parent.
Thank you, Mr. Chairman. Thank you, Senator Chairman Cowser. So as I understand it, and you already went over this a little bit, I may have missed something. Right now, the trial judge has the discretion to do this. So the legislation would be, in your estimation, make it much more likely that would occur.
It just gives that trial judge guidance down what issues to consider in making the decision. Right now, it's just wide open. He gets to do it to avoid prejudice, but there's no factors as to what that constitutes here. And these other issues that I lay them all out there from lines 24 through 34, what the judge ought to take into account in rendering that ruling.
That you're finding in your practice that they're not taking these things into account?
There's just no roadmap for them, and so that they're not required to take any of these specific little issues that I lay out into account. Maybe implicitly they are, but there's no roadmap for them.
I see. Follow-up, or kind of a related question. I was reviewing the letter that we have in support of the legislation.
Yeah.
And your bill, as I understand it, applies to all civil actions. Am I correct?
For tort cases.
For tort.
Not contractual damages. Yeah, you can see a wide variety. All the Chamber of Commerce, many medical groups, business groups, all think that this would create a fairer playing field.
Well, the reason I brought it up is the letter seems very focused on medical malpractice. So I was wondering what's the rationale for not maybe limiting this to med-mal?
You could, but you also have the Georgia Chamber of Commerce that represents the entire business community there. I've had, all kind of business groups come tell me that they support this concept. A lot of the premises liability cases that have occurred, we've heard about the CVS case, the Six Flags case, all of those type of businesses are saying, this verdict went crazy because the person was injured, and then they put 95% responsibility on CVS because they know we're a deep pocket. They're already biased after hearing the damages before deciding were we in some way at fault for providing inadequate security or whatever the issue might have been in the case.
Thank you.
Here are questions for the author of the bill. Senator Hatchett.
Is this trial bifurcation done in any other states?
I know it's done in North Carolina. They have had good success with it here recently, but I hadn't studied the other states. Our Civil Practice Act is not exactly a uniform bill, but it's very similar to most states, so I'm sure that they all have that. Well, I'm not sure, but I expect most of them have that option. I don't know what parameters or guidance they give them.
How does, and Mr., if I can follow up, in North Carolina, how does the first phase of a bifurcated trial work as it deals with damages? How are damages mentioned at all?
I do not know. I think there may be some speakers to come up here on that.
I can hold my questions till they come up.
Here are questions for the author. Or we do have a couple people signed up to speak, but I believe we're down to one person in favor based on a text I had. Stephanie Kindergan. Do you have Barrett Johnson that you're going to call in? Is that correct? Okay. And so she's going to call him on the phone. Okay, he's already here. I'm going to get you mic'd up. Let's see if we can make it.
Are you there?
Yes.
All right. Can y'all
All
hear
right,
this?
get everybody, let them start talking. We'll see if we can hear it.
Technology we're working with.
Yeah, this is the technology of 2021.
And am I okay? Or mask on, or y'all 6 feet away? Am I good?
As long as they're comfortable in front of you with it off.
Are you comfortable? Okay. Good morning, I think. I am Stephanie Kendrigan with Mag Mutual. Thank you for having me here today, and thank you for Senator Calzert for bringing this legislation. I have on the phone with me Barrett Johnson. He's one of our attorneys in North Carolina. He's actually with Huff, Powell, and Bailey up there. Before I turn over him, obviously Senator Calzert referenced North Carolina, and so we thought it would be good to have defense counsel from that state kind of talk through how this has worked and played out in North Carolina. We're constantly trying to look at ways to improve the environment for our policyholders. We represent about 55% of the healthcare providers here in the state of Georgia. And as you can imagine, a medical malpractice claim against a physician is very taxing on them emotionally, physically, mentally. And anytime we can find deficiencies in the system, that's a benefit to those physicians. And obviously, if we can limit the amount of days in courts, that's good for the courts, but it's also good for that physician because they can get back home and be practicing medicine. And so in 2011, at the urging of the North Carolina Medical Society, the North Carolina legislature enacted trial bifurcation. And so I'll let Barrett talk a little bit about the policy considerations that state did then, and then why they thought this was good public policy, and then how it has actually played out over the last decade. So Barrett, I will hand it over to you.
Thank you, and good morning, Mr. Chairman and members of the committee. Thank you for having me. So as Ms. Kendrigan indicated, I am Barrett Johnson. I'm a medical malpractice defense attorney in Raleigh, North Carolina. And I'd like to talk a little bit about our experience with bifurcation of jury trials on the issue of liability and damages that we've seen here in North Carolina. So our law went into effect in October of 2011, and it applies to any tort action where the plaintiff seeks more than $150,000 in damages. And in those cases, on motion by any party, the trial court is required to order separate trials on the issue of liability and damages, with an exception that if good cause is shown, the court can order a single trial. In our experience, this change in the law has been interpreted by trial courts as being quite mandatory, which we believe it was intended to be. And we have not had any cases where good cause for not bifurcating the trials has occurred. And in fact, the cases in which that is asked for or sought by plaintiff's attorney are few and far between, and I cannot recall a single one that our office has had. The law also requires that the same jury that tries the issue of liability will also try the issue of damages, so you're not starting all over if liability is found. So we've seen here in North Carolina, from our perspective, in the medical malpractice realm, I think two categories of effects that this change in the law has had over the past 9 years. One of those effects is judicial economy, and the other effect is really fairness from the defense perspective, and also in certain cases that I'll talk about shortly from the plaintiff's perspective. So this we know in North Carolina, based on surveys, studies that appear in law review articles, that kind of thing, that most cases, most medical malpractice cases that get filed do not find their way to trial. Most cases settle, or they go away by some motion, or whatever the case may be. Now, the majority of cases that do go to trial in the medical malpractice field in North Carolina, we know from various studies that the majority of those cases result in defense verdicts. Depending on the study that you look at and the time frame and the counties involved and that kind of thing, you'll see that it's always over half, and some studies say up to 80% of medical malpractice lawsuits that go to trial result in defense verdicts. And so what this bifurcation of trials does is it saves days off of about 80% of medical malpractice trials that occur in North Carolina because they result in defense verdicts, and there's no reason to have damages information being put on before the jury. And in our cases, a lot of times there'll be experts that testify solely on the topic of damages. So in those 80% of cases, those experts and the time that accommodating an expert's schedule takes up, those days are entirely avoided because there's no need for damages testimony because liability is not found. We've also seen another way that I think is kind of novel if you think about it, that this law has resulted in shaving days off of trials, and that's when you get a plaintiff's verdict that really jumpstarts settlement negotiations. And so if a jury comes back and finds liability on the part of a physician, both sides really have quite the incentive to discuss settlement in order to avoid the uncertainty of a jury assigning a number to damages, and also to avoid future appeals. And kind of, I think, an interesting side effect that we've seen of this law is that we hardly ever see appeals from plaintiffs' verdicts in medical malpractice cases in our practice, because those cases tend to settle after liability is found. The cases that we see appealed involve directed verdicts, summary judgment, that kind of thing. So that's another way that this bifurcation impacts judicial economy. As things move forward here in North Carolina, we can rest assured that these shaving off of days with respect to trials and then also avoiding appeals will make things easier as we get through this backlog of cases that are on all the trial dockets because of COVID. The second impact of bifurcation that I wanted to talk about that we've seen here is that we believe it makes jury trials more fair. So from the plaintiff's perspective, you'll often have a very sympathetic situation. But we know, as defense attorneys and physicians know, as practicing physicians, that bad outcomes can happen in medicine that have nothing to do with any negligence. But that's a hard point to convey to jurors when you have someone who's paralyzed, or a child with a tragic brain injury, or someone who's passed away. It's very difficult to make sure that the jury sees that just because there's an injury, that does not mean that negligence has occurred. And really evidence of the damages and of the tragic nature of a plaintiff's situation, I think weighs on jurors, whether consciously or subconsciously. So keeping evidence out that relates solely to damages until the jury has determined negligence prevents that sympathetic evidence from impacting the jury's determination of negligence. We have a jury instruction here in North Carolina that says you are not to assume negligence occurred based solely on the fact of injury. If a jury is sort of bombarded with evidence of damages regarding an injury for days and then tasked with deciding liability, it's very difficult for the jury, I think, to conceptualize that, hey, just because there's been this tragic, catastrophic injury, that doesn't mean, and that shouldn't weigh on our decision of whether negligence has occurred. Legally speaking, we know that evidence of damages is not relevant to the determination of liability. Whether someone was negligent has nothing to do with how much someone is suffering, how much monetary compensation someone has lost, how much future care for the life of a plaintiff is going to cost. None of that has anything to do with the task of determining liability. But when you're a lay juror and you're put in a position of evaluating very complex medical cases with scores of experts brought in to testify on standard of care, on causation, and then without bifurcation, damages, it's hard to prevent the evidence of damages from weighing on the jurors. And we've seen cases where this bifurcation of trials is sought and requested by the plaintiffs. It can be, so it's mandatory on motion by either party, by any party. And we've had cases where plaintiffs make the motion to seek it, and it's generally a consent motion, and the judge orders it. And a lot of the cases where you'll see this happen from the plaintiff's perspective involve cases where liability is pretty clear, at least from a certain perspective, but damages are either not terribly concrete or not overly catastrophic. They're more headaches, kind of things that cannot be concretely documented. And so the plaintiff's attorneys in those cases don't want the jury to, when they're weighing liability, to bypass all of this evidence of liability and just think, well, this plaintiff says he or she has headaches, but I mean, do we believe that? Let's just find no liability. So what we've seen, we believe that the mandatory bifurcation of jury trials in North Carolina on issues of liability and damages has really made trials more fair. by keeping out irrelevant evidence, they can sway the jury one way or the other. And they also promote judicial economy by preventing a waste of time in the majority of medical malpractice cases that go to trial that result in defense verdicts. And then also, when a plaintiff verdict occurs, by jump-starting those settlement negotiations, which, if a settlement is reached, would result in no future appeals for that case. So that's all that I have for you. I'm happy to take any questions. And again, thank you for having me.
Thank you, Mr. Johnson. We do have some questions. Senator Hatcher. Is it Hatch or Hatcher? Hatcher. Okay, Senator Hatcher.
Thank you, Mr. Chair. I have a quick question. When there are multiple defendants, how does the bifurcation work in North Carolina?
So it's bifurcated between liability and damages, just the same way as if there were only one defendant. So all of the defendants undergo a trial on liability, where liability regarding each defendant is sought to be proven. And then if a plaintiff's verdict results, there's the same jury that considers damages. And so in North Carolina, we have joint and several liability. So they're not apportioning damages to any given offendant. They're just saying plaintiff has sustained X damages, and then our law permits recuperation among joint tortfeasors that can occur sort of behind the scenes so that everyone pays their fair share. But from the jury's perspective, it's just liability in the first phase. So was plaintiff injured by the negligence of physician A? Was plaintiff injured by the negligence of physician B? Was plaintiff injured by the negligence of physician C? Then you get to the damages phase, and it's just how much is the plaintiff entitled to in economic damages and non-economic damages against all defendants.
And Mr. Chair, if I can follow up. That was actually going to be my next question. Here in Georgia, we have much more favorable laws for physicians because of the 2005 tort reform and the issue of apportionment. So a jury gets to apportion fault or non-fault and damages to different actors. In North Carolina, obviously it's joint and several, so if liability is found, if any of those defendants are insolvent, a doctor could be on the hook for the entire verdict. And my question here with this trial bifurcation is, if you have a 30, 45-year smoker who is in a car accident that was caused by someone else, who goes to the hospital and loses a lung and sues the doctor can never say, yeah, but yes, she lost a lung, but look what all happened leading up to that, and they would never be able to defend themselves from an apportionment argument. And I'm worried that this is, while it works in North Carolina, Georgia and apportionment in Georgia would in fact, and I'd like to get your opinion, I think it would actually hurt the medical community.
I'm not sure that it would. So the situation that you mentioned with the lifelong smoker who has a car accident and suffers a bad outcome with a physician in the hospital, there would be causation defenses to the outcome and that kind of thing. I guess if liability is determined. And there are two defendants, liability is determined against both. Then you go into the damages phase, and I suppose in Georgia you would still be assigning a percentage of liability. So it seems like it could be done bifurcation. I don't think bifurcation would impact the ability to assign percentages of liability in that damages phase. And in fact, it might help even more because you're not spending all of the time and all of the resources trying to prove defendant A is this much responsible, defendant B is this much responsible, defendant C is this much responsible, and having all defendants A through C combat each of those allegations of percentage of responsibility in the liability phase. You're saving that all for the damages phase once it's liability has been found.
And just one more. So with the bifurcation of a trial, are you saying that we would be able to apportion fault in the first phase and then only look at the damages in the second phase. I have a hard time because I feel like there's a causal connection between the injury itself and the negligent acts that led to that injuries. I mean, duty, breach, causation, and damages. If you can't talk about causation and damages, how is a jury going to apportion fault in the first phase? And in the second phase, we're going to have to deal with apportioning, the monetary value of damages. I think it's a great system in North Carolina, but because of apportionment here in Georgia, I have a lot of pause to support this.
Understood. And so my thought is that the apportionment portion of the trial would occur in the damages phase. And we know that duty, breach, causation, damages is an essential element of torts. And so the North Carolina rule states that evidence relating solely to compensatory damages shall not be admissible until the trier of fact has determined the defendant is liable. And so in all of our trials, in the liability phase, the jury hears that plaintiff has died, or the jury hears that plaintiff is paralyzed. But what the jury doesn't hear in that liability portion of the trial is decedent's death, how it has impacted his family and how they're suffering, and paralysis of plaintiff, how that impacts the plaintiff on a day-to-day basis, and that kind of thing. So you hear in the liability phase the existence of damages, but you don't have the admission of evidence that relates solely to those damages.
Okay, and then just one more question, if you don't mind. I'll get away from this for just right now, because like I said, I do think it would be better in a joint and several jurisdiction, and I don't think the Georgia Chamber wants to go back to joint and several at this point. But the last thing that I want to say is something you mentioned earlier, that you said you noticed in North Carolina, when liability is clear, plaintiffs that don't necessarily have the injuries or the damages will actually try to bifurcate the trial. And what I hear that is going, in my opinion, could encourage frivolity in the courtroom, because if I don't have the damages, and I know I don't have the damages, but I know someone was negligent, then I would definitely pursue, if I'm a plaintiff, pursue a case where my damages are not presented, but this clear negligence is presented. And in those situations, if we're trying to alleviate the court's burden hearing all these cases, I think it could potentially slow down the court process or the judicial process. And I'd like to hear your thoughts on that, and how that would be played out here.
Sure. Yeah, I think so. So in those cases where there's arguably clear evidence of liability, but kind of tenuous evidence of damages or damages that aren't so concrete, that kind of thing. So I think it actually plays the other way in discouraging frivolous cases from going to trial. And the reason for that is if you have a case where liability is clear but damages are somewhat lacking, attorneys can sort of almost conflate the two issues during the liability phase, if it's not bifurcated, and show, X physician was really negligent, and, we have these sort of small or lacking damages, that kind of thing, and in hopes that the jury would let that clear evidence of liability kind of weigh on their decision in assigning a number to damages. Even if that weren't to be avoided, I think at the end of the day, the liability phase, the damages phase, is going to roll around, so I don't. From my perspective, we haven't really seen anything to suggest that these frivolous cases or cases with totally lacking damages are being brought more often or with greater frequency or anything. I think it's more, cases where damages are somewhat non-concrete, headaches, pain, that kind of thing, that you can't see on an MRI, where the plaintiffs don't want that to kind of weigh in the defendant's favor in the jury's mind, for them to just say, well, what's this plaintiff so worried about? They don't have any concrete injuries.
Thank you.
Any other questions for Mr. Johnson? All right, thank you so much for calling in.
Thank you, Barrett.
Thank you.
Do you have anything else? Okay, thank you. Only other person signed up to speak on the bill is Mr. Pope again.
Good morning again. My name is John Pope again on behalf of the Georgia Trial Lawyers Association, here to speak in opposition of Senate Bill 189. I think, again, having the ability to come up at the end after having heard some good discussion, I think a lot of the comments I would make have been made. But I will point out one thing. North Carolina, we can find no other state that that mandates bifurcating trials. And in fact, I was unable to find any similar law in the United States similar to this law, this proposed law, Senate Bill 189. And I would say in that regard, North Carolina is sort of an island. I think one of our main problems with this law is that it is basically saying that we do not trust our judges to use their discretion that they currently hold to determine when bifurcation is necessary. And moreover, we're also saying that we don't trust the citizens of Georgia, the jurors, to be able to make the distinctions between liability and damages. Furthermore, this law, despite what I think has been argued, this law will create more trials. It will create longer trials. It will bog down our already backlogged court system. Obviously, we all know that our court system is backlogged because of the pandemic. It does things such as remove incentives to resolve cases, and certainly gives insurance companies multiple bites at the apple in these cases. I think it, unlike the counselor from North Carolina indicated, I think it will result in more appeals to we have the busiest appellate courts in the United States. It will force judges to engage in really an imbalanced analysis that focuses really solely on the corporate and insurance interests, while really completely ignoring the interests of the plaintiff, the victim. And lastly, I would point out that what is, again, I think obvious, our judges have the discretion now, as we sit here under our law. They have the discretion to bifurcate a trial anytime they see fit. And in that regard, this law is unnecessary. I will say, it is important to note that the decision to separate the trial of liability from damages, it isn't really just an issue of trial management, but it can very well impact the outcome of a trial. It's like trying a case in a vacuum or in a laboratory setting, because the jury doesn't hear the whole story, only part of the story. I'll take this off if everybody's okay. Okay. It's kind of like telling a joke without hearing the punchline. And I think it can negatively impact the rights of victims in Georgia. I'll give you some examples of some of the problems that this statute would create by encouraging more bifurcated trials on liability and damages. Number one, product liability cases. Cases in states or like in Georgia where we have strict liability. The main liability issue in a product liability and strict liability case is whether the product is unreasonably dangerous to the user or consumer. Now, how can jurors in a bifurcated trial on liability determine whether the product is unreasonably dangerous to users or consumers if they don't know the extent of damage? that the product caused. For example, one juror might say that a product that, cut someone's finger is not unreasonably dangerous, but another juror might find a product that, where someone's hand or arm were cut off is unreasonably dangerous, and they can only make those determinations by hearing the extent of the damages. Bifurcating trials in medical malpractice cases is particularly problematic. As has been mentioned, a medical malpractice case it requires medical testimony in liability, causation, and damage portions of the trial. For example, in many cases, and I'll say beyond medical malpractice cases, in any cases, you may have an eyewitness to the collision who also witnessed the injury. Well, that witness if the case is bifurcated, that witness is going to have to come and testify in the liability portion of the trial. And they're going to have to be recalled again in the damages portion of the trial. As I mentioned, it's particularly problematic in medical malpractice cases because of the issue that it is common for the expert, the medical doctor, to testify as to the standard of care, which would be required in the liability phase. But then that same expert would be required to be recalled during the damage phase to talk about the issues of causation and damages and the injuries as a result of the malpractice. Now, there is not something that really has been talked about, but there is an issue of juror bias and prejudice as a result of bifurcating liability and damages. It has been in many studies and articles, it's been cited that if jurors are not told the extent of damages suffered by the plaintiff, there is a bias factor against the plaintiff that's increased. Many jurors verbally express in jury selection, and many of the lawyers here, trial lawyers, have heard that they're not interested in cases where the damages are small or not obvious. If the jurors aren't told details about causation and the extent of injury, and if the plaintiff's injuries aren't visibly apparent, the jurors may have difficulty conceptualizing why they're there. Now, in many cases, too, jurors are going to know at the outset that they're going to be required to return to try the damages phase if they find for the plaintiff on liability. In other words, if they know in advance the case is going to be bifurcated, they're going to know if they find for the plaintiff, they've got to come back. And the reality of it is that can result in jurors finding in favor of the defendant. So they realize, hey, I won't have to come back. Again, I think much of, the arguments in opposition of this bill have already been made. I just think that what it really comes down to is we need to trust our judges. They have the discretion now, and we need to trust our juries that they can make the determinations between liability and damages. And again, I'm here. Thank you for your time. I'm happy to answer any questions.
Question from Senator Kirkpatrick.
Thank you, Mr. Pope. I just am confused about the point about things taking longer or shorter, because it's my understanding that with just MagMutual alone, since 2016, they've won 94 cases. So this would have saved them 2 days on each one. So that's 180 court days that would have been saved. So that's just one company. So I'm trying to understand your point about how this would actually delay things more.
Well, I think the assumption is that the cases are going to be lost. And that I think is the problem with we don't know. The idea is that if the case is valid, then it's going to be longer because the jury's going to find in favor of the plaintiff, and then we're going to have the second trial, and many of the same witnesses, especially in a medical malpractice case, are going to have to be recalled. It's going to drive up the costs. It's going to lengthen the trials. Are there cases where it would shorten? Certainly. But again, I would say, Senator, the judges have that discretion now. Any defense lawyer in a medical malpractice case can request the judge to bifurcate the trial as we sit here today.
Dr. Watson.
So in North Carolina, did he say 80% of the cases that they had won? So, I mean, so you're saving time on 80% of the cases. The issue I have, and I mean, this is older data, but National Conference of State Legislatures, I mean, that's pretty unbiased group. North Carolina apparently allows it now, but I think that no state other than North Carolina specifically requires it, but it appears that most, if not all, states allow the judge to bifurcate it. Federal rules also allow that also. Connecticut in court rules, statutes and court rules permit bifurcation also. So it sounds like a lot of them. Missouri requires bifurcation in cases tried before a jury that seeks punitive damages. New Jersey and Arkansas require bifurcated trial if a party requests it. New York court rules also. I mean, it just keeps on going on and on. Wow.
And Georgia does too.
It's just they're just not doing it. Is that what it is? Is that why?
No, I don't think there's been any evidence to indicate judges aren't doing it. I don't know if I think again there's been no evidence presented that judges aren't doing it. I think that would be a good question and maybe something that should be looked at before we pass this type of bill. But I would say that yes, the overwhelming majority of states do exactly what Georgia's doing right now and leave it in the discretion of the judges.
On that note, I asked this earlier to Senator Cowser, and I think you mentioned there was one time he tried to do it, but in your experience with your members, are these motions being made right now in court? Do you know? Pursuant to that code section?
In my 25 years, I've had one motion filed, and the judge granted it.
Okay. Senator Kennedy.
Thank you, Mr. Chairman. Mr. Pope, on the time-saving argument, I too, like Dr. Kirkpatrick, am having trouble following that because, as I understand, what you're saying is that in Phase 2, you will be recalling witnesses that were called in Phase 1, and therefore that's going to increase the overall length of the trial. But doesn't that ignore that the witnesses that you're contemplating, and I think correctly talking about, did not testify as to those portions of testimony in Phase 1? So your argument kind of assumes that they're duplicating the testimony and therefore increasing the time when in fact they didn't testify as to that particular provisions or damage specifics on damages. So certainly with court inefficiencies that happen at trial, there may be a little more time, but it's I don't think it's fair to say that it doubles it, and you didn't say double it.
No, I agree.
But it ignores the fact that that ground, if you will, wasn't covered in Phase 1 and now has to be covered in Phase 2 if liability attaches.
Yeah, I definitely agree with you, Senator. I don't think that the length is going to be doubled by any or any stretch, but obviously you've got to conclude the first phase of trial. The jury has to deliberate. There's going to be 2 deliberations potentially. Jury instructions. It will significantly increase the time, but obviously that's not the major reason. I just think there's some major inefficiencies to it. And again, everybody uses the medical malpractice cases as an example, and maybe that's where the law is sort of aimed. But obviously, with some of these more significant cases, with multiple experts, expense associated with that, I just think I think we've got a law in the books right now that gives the judges discretion. I don't really see there's any problem with it, and let's trust our judges and our jurors to make those decisions.
Mr. Chairman, one more. And when you speak, Mr. Pope, of those major inefficiencies, you're speaking in terms of cases where liability is found and you have to go to Phase 2. That clearly wouldn't be the case where liability is not found, because now in those circumstances where the trial was bifurcated, you've got significant efficiencies, not inefficiencies, but efficiencies that are found in the system, correct?
I agree with you, and I would say there's a little bit of like the chicken or the egg, because we're talking about in North Carolina, for example, that 80% of the trials result in a defense verdict. And I believe he said since 2000, since this law was passed, and I think that there's a real prejudice to victims, to plaintiffs in bifurcation in many cases, because again, some of the things I mentioned, the jurors know if they decide there's no liability, they know their job is done. And in many cases, we all know jurors would rather be any place than the courthouse. So I think that plays a role in it. I think that there is a prejudice or bias to it in many cases.
But I thought you said we ought to be trusting our jurors, Mr. Pope. Sounds like maybe you don't in all cases. Thank you.
Okay.
Senator Hatchett.
Is it, I guess, with the bifurcated trial and the new language to expedite or economize that's been added here on lines 12 and 13, the only time a bifurcated trial is more economical is when you never get to the second phase, right?
Yes.
Okay. Thanks.
Any other questions for Mr. Pope before we start seeing lawsuits against the Judiciary Chair and we have to divide it in two separate trials based on the damages of sitting through this hearing this morning? No offense to you, you just happened to be up there when I said that. All right, thank you, Mr. Pope.
Thank you.
We had a member, Senator Kirkpatrick, wanted to ask another question from Mr. Johnson, is that right, or Ms. Kingergan?
Well, Ms. Kindergan could probably
step back
answer
up.
it. My question is, because you cover multiple states, I'm just wondering what the difference is that you've seen between the rates for North Carolina versus Georgia, for example.
Of course. So in the med-mal market, an OBGYN in Georgia pays about 52% more than their counterpart in North Carolina. It's about a 49%, I believe, for internal medicine. General surgery is right in the 50%. I think it may be 54% more they pay in Georgia. So it's higher rates in Georgia than North Carolina. North Carolina has some of the lower rates in the Southeast.
All right, thank you. You want the last word again? Okay. No one else has been signed up to speak on the bill. What's the pleasure of the committee? Senator Kirkpatrick.
Move to pass.
We have a motion to pass by committee substitute on this one. Is that correct? By committee substitute by Senator Kirkpatrick. Do we have a second? I have a second by Senator Watson. Any discussion? All those in favor of the motion, please raise your hand. We have 4. All those opposed, like sign. We have 4. The motion fails.
Point of order, Mr. Chairman.
Yes, sir.
Your rules say the chairman shall not vote unless the committee shall be equally divided, or unless his or her vote, if given in the minority, will make the division equal. In case the vote is equally divided, the chairman must vote.
Unless it would move the bill forward, I believe, correct?
It doesn't say that in your rules. I'm looking at number 10. I was thinking about that on the last bill, so I pulled up the rules to check.
You are correct. And I vote against the motion. So the motion will fail regardless.
All right.
We have one more bill out of order we're going to go to. And we'll come back to Senate Bill 190. Senator Kennedy has Senate Bill 234. Let's make sure we get to it in our... I'm showing LC 413029S. Is that right? You have a substitute? Okay.
Thank you.
Go ahead. Yes. Let me get you a mic on.
Okay. I'm going to be brief with my opening comments because I'm going to ask Mr. Sewell, Rusty Sewell, to come speak to this. So to the committee, this bill will sound familiar, but a substantially similar bill last year out of the committee and out of the Senate went to the House where it did not move. There were some certain concerns, and those concerns have now been addressed. I want to thank Mr. Sewell on behalf of the bar. I want to also thank the folks from the GTLA that had some concerns about some language in the bill, and they have worked collaboratively since last year, and I think we have a good bill for the consideration. Mr. Chair, because of Mr. Sewell's on a short time frame to get to another committee that he has to testify, if I could stop there and ask him to present, I'd appreciate that. Thank you.
Mr. Sewell, if you want to come on up.
Thank you, Mr. Chairman. My short time frame is the rules chairman wants me over at finance real quickly. So, but anyway.
Taking the rules chairman
Yeah,
over us.
and so if I
That's
make
fair.
him mad, it doesn't matter how I testify on
That's
this,
fair.
it won't get out of rules. But anyway, this is the mediation bill, as Senator Kennedy said, that y'all took up last year. What we're trying to do is, I mean, we always, and again, let me go back, I'm Rusty Sewell and I represent the state bar. What we're trying to do is something that kind of everybody agreed to. Now it's just getting down to the right wording. We want to protect things that go on in the mediation. We don't want the mediator where, and the information in there. A mediation is supposed to be a time where you come together, talk about everything, go through ideas, say things, and now what we're trying to do is make sure that those things in a mediation stay in a mediation, unless the exceptions that are outlined there. There are some things like when we're talking about crimes and other things that should be out, and the judge will decide that. And also we want to make sure that in this law, we don't change the evidence code and what it protects in there. We also have a number of other mediation things that I have found over the last year and been brought to our attention. There are a lot of compacts that we have with other states that have mediation provisions. Our open records law has mediation provisions. So this has not been an argument about should you or not should you or whatever. The whole argument, and as Senator Kennedy said, we've been working with the lawyers, most of them with GTLA and most with Jordan, has been extremely helpful, of going through there and making sure that we're not harming anything or allowing something to get out that shouldn't be. I have today, I'll answer any question the committee has, but I also have an expert here in Steve McKinney, who actually not only is chair of the dispute resolution section of the state bar, but he's also a mediator. That's his profession in arbitration, an arbitrator and a mediator, and he can kind of give you from that standpoint of what the value of this legislation will be. So if there are no questions from me, if that's all right, Mr. Chairman, Steve can come up. I do want to say that Tracy Johnson is here. Tracy is the executive director of the Supreme Court's Commission on Dispute Resolution, and they are very supportive of this legislation, the idea also.
Okay, that's fine. If Mr. McKinney wants to come on up.
All right.
Mr. Chairman and committee members, thank you for giving me just a few minutes to hit the high points of this legislation. As Senator Kennedy pointed out, this is a bill that in substance is the same bill that was passed out of the Senate last year. Didn't quite have time to get the hearing it needed in the House last year. I am a commercial litigator and also a full-time mediator and arbitrator. Have been involved in mediation since the early 1990s. Back then, mediation was so new that nobody even knew the difference between the words mediation and arbitration, and they often got mixed up. Now, mediation is ubiquitous and absolutely vital to civil resolution in Georgia and the rest of the country, and indeed around the world. Three things are addressed in this statute that are of utmost importance. One is the creation of a privilege for private mediations. There is a privilege of a sort that has been accounted for in the court-annexed mediation rules in the statutes of Georgia, and there has not been a privilege for mediation communications in private mediations. And this privilege is in support of confidentiality, which is the lifeblood of mediation. Without candor and transparency in mediation, the process simply doesn't work. The second provision that is key here is that this Georgia Uniform Mediation Act provides for some consumer protection for the parties who are participating in mediation, in that it requires the mediator to make disclosures of potential conflicts of interest. Because mediation is so ubiquitous, as you can imagine, there are attorneys who work with the same mediator on multiple occasions. I think that it is very important that the parties have an understanding that the mediator that's chosen may have a relationship with their lawyer or with the lawyer for the other party. And the need for that being disclosed allows the parties to understand any particular biases the mediator may have. And finally, and not insignificantly, the Georgia Uniform Mediation Act would provide Atlanta with a boost in a feature of Atlanta's development that is entirely healthy, both for the economy and for the bar. It has been the case in places like New York and Chicago, where airports allow parties to travel in and out very frequently and seamlessly, that those locations have become traditional locations for citing mediations and arbitrations, because parties from all over, even all over the world, can get in and out very easily. Atlanta has really picked up on that trade and is becoming just as much of a situs of preference for parties who are mediating as Chicago or New York. In fact, a significant amount of my work involves what I call destination mediation, where I am called upon to serve as a mediator for a dispute that's not even cited in the state of Georgia. The Georgia Uniform Mediation Act would provide parties both overseas and around the United States to have some statutory confidence that if they are to come to Atlanta to mediate with Atlanta mediators, that they have confidence there is a statutory provision providing for and protecting the confidentiality in that process. Thank you again for your time. If there's any questions, I'll be glad to answer.
Questions? Question for Senator Kennedy? Oh, I thought you had a question.
No, sir.
Okay.
Oh, wow, no.
Any questions for Mr. McKinney? All right, thank you.
Thank you.
Anybody have any questions for for Rusty Sewell as well, or the author? All right, nobody else signed to be heard on the bill. What's the pleasure of the committee?
Move to pass.
We have a motion to pass by Senator Calzert. Second by Senator Parent. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? It passed unanimously.
Thank you, Mr. Chairman. I want to thank Mr. McKinney for being here, as well as Ms. Johnson. Thank you for your work on this. This has been a long road for these folks, a couple of years, in fact, working on it. So thank you very much. And I thank the committee for your vote.
I apologize. We were discussing some scheduling based on other commitments people have on the committee as well. We're going to once again go a little bit off the agenda. We're going to hold on Senate Bill 18 for today, Senator Jones's bill. We're now going to move on to Senate Bill 276. The last on the agenda is Senator Kennedy. And We're working off LC 470928. And the floor is yours.
Great. Thank you, Mr. Chairman. This truly is a simple bill. What it allows, well, let me back up. Courts can charge a filing fee, I think under the statute, up to $5 that goes to the, or can go to the maintenance and cost of a law library. Magistrate courts, though, are excluded from the defined courts that are allowed to charge that. With the decreased filings across the state, we now have areas where the public, the law library that's available to the public are having difficulty in meeting a budget and actually keeping the doors open. There's one county in South Georgia where they used to have a librarian for the law library, but they had to eliminate the position because of not having enough funds for that. So this simply allows, and it doesn't mandate, it allows the magistrate courts to charge if, in fact, the governing authority passes an ordinance or resolution approving of such charge or fine.
Any questions for Senator Kennedy on Senate Bill 276? No one signed up to be heard on the bill. It's the appropriate time. What's the pleasure of the committee? Senator Kirkpatrick moves to pass. We have a second by Senator Hatchett. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? It carries unanimously.
Thank you, Mr. Chairman.
Thank you very much. If the committee can still stick with us, we'll knock a few more of these out if everybody's still good. Kind of good, Kay. Okay. Fair enough. Is Senator Anna Vitarte back in the room? Or before we get to that, let's go back up the agenda. Senate Bill 238, which is my bill. And we are working off LC 338590. This bill is also a simple bill. I'll tell you what we're doing with it. This comes from our Code Revision Commission. You'll see in the bill, based on a Supreme Court decision where you had the issue of what our legislature actually prepares as part of our code. And this bill confirms that when we are entering into a contract, as our Code Revision Commission does, which includes the Speaker, the Lieutenant Governor, appointees from the House and Senate, and also from the State Bar. The contract we enter into is for the code itself to be prepared, which is obviously available for the public, something that's on our website, the General Assembly website. That code book that Senator Calzer had earlier has that in there as well. But what's also included in those code books are annotations. Earlier when I was asking about how courts had interpreted a statute, well, what you would do is pull that code section up, suppose there are not lawyers in the room, and it has annotations below that. They're prepared by the company that produces the code. What we're doing with this bill is confirming that those annotations are not part of what the Georgia law is. The issue is if we did not, there was some dispute, and obviously the Supreme Court in a 5-4 decision, majority said that the way the current law was written, all those annotations are also authored by us, the legislature, through our Code Revision Commission, which means suddenly we are now producing annotations that will be available to all the public for free, when that's obviously not what our intent is with the code, where the code itself is what we author, and the annotations are not the law, and is not something that we are providing to everybody. And so this bill confirms that. It confirms what the Code Revision Commission is doing, confirms that the code itself is the law, and not those annotations included with that. I'll be happy to take any questions. Dr. Watts.
So do we charge for the annotations, or who charges for that, or is there a charge for it?
So yes, there would be a charge for that. It's not something we do, and that's what we're confirming in here. So the annotations is sold separately, and that's something that LexisNexis, Westlaw, their companies do sell, and it's something they gather, and there's work product associated with that, and obviously copyright associated with that. And so it's not something that we sell. But the Supreme Court decision leaves open the idea that annotations are actually part of the code itself. And that's what this clears up, that the code is just the code. But as far as the public, what the public gets from us through the Code Revision Commission is the code itself.
At the proper time.
Any other questions? Now is the proper time.
Move do pass.
We have a motion do pass by Senator Watson. We have a second. Second by Senator Kennedy. Any discussion? All those in favor of the bill, please raise your hand. Any opposed? It passed unanimously. Senator Anavitarte, you arrived just in time for Senate Bill 226. All right, we are currently passing out a sub. Before you start, I'll state probably what you're about to say too is I encourage the author of the bill to get with some of the other folks involved on this, that some of the stakeholders on this issue, because it seemed like there was be frank, an easier way of doing this that everybody could be on the same page with. And I appreciate the Senator for working on that while we've been hearing these other bills this morning. And there is a substitute. I'm not sure if that is what you're going to have us move on. You may have some other language you want us to consider possibly for tomorrow. And so with that, I'm going to give you the floor and let you present Senate Bill 226.
Thank you, Chairman Strickland, committee. Sorry for being a little bit late. So in front of you, you do have a committee sub for Senate Bill 226. We're not going to move on that bill today. We just wrapped up a discussion with other stakeholders, including the local school districts and the Department of Education, related to this bill. And my goal is this afternoon to have some sort of compromise language that we all can agree on and live with for your meeting tomorrow. So I'll just state that kind of up front. I do want to present just kind of why we're here today, and I think there's some other groups that are signed up that are here to also speak with me. So I'm just going to give some comments, and I'm going to turn it over to Cole Musio, Brittany Ellison, and a couple others with the Family Policy Alliance. Basically, in a nutshell, we're here because there are obscene and harmful materials in our school system. I am a father of 3 daughters. I'm a former local school board member, heavily involved in our community, just like so many other parents across the state. And the access that parents have in this day and age, whether it's books in libraries or online materials, I don't know that we're doing enough to protect our kids from obscene materials in our school libraries across the state. And I just want to be clear that we're here to talk about material that is in a school library, not what's going on in the classroom. That's not our intention. Not the impact of teachers. We're not trying to criminalize librarians or anything like that, but just deal with the material that some of our kids could be exposed to in a school library on sites and databases such as Galileo, EBSCO, and others, in terms of individuals who potentially either could be knowingly distributing that information or being able to access it through these databases online. So just with those comments, I'm going to let the folks with me just give some comments unless there's some initial questions by you, Mr. Chairman, or any of the senators on the committee.
Any questions for the author before we hear from some of the other folks on this bill? Okay, let me look at who signed up to be heard first. We have Mike Griffin with the Georgia Baptist Association. Is Mike in the room? Okay. Do you want to be heard, Virginia, in his place?
No, I think I'm on there, right?
No, I don't see you on here, but if you want to be heard, you can come on up in his place if you want to be heard now.
I'll let Noel go first.
Okay.
I'd like to be heard like
Yeah.
I'll ask Mike to come down here.
Noel, do you want to come on up?
Thank
Yeah.
you.
Hey.
Thank you for having me. I really appreciate being here. I'm a health teacher in private and public school. I'm also a parent. And I feel like I'm fighting a statewide forest fire with a water pistol. The worst thing that happens in our schools is the sexualization of our children with taxpayer dollars. Once they've been desensitized, they are easily preyed upon and groomed. The Department of Education and legislators were alerted to this problem last year. Nothing was done. No one contacted me. No one contacted Representative Karen Mathiak. Right now, Georgia law says it is illegal for all school personnel to provide obscene materials to minors. So the janitors can't, teachers can't, coaches can't. The penalty in our current law is a misdemeanor. I have never heard of one of these people being charged because they follow the law. School libraries should be held to the same high deterrence. However, criminalizing media center personnel is not the goal. Protecting our kids is. So you have a packet in front of you, I hope. No one has a packet? Oh, you have packets, great. This is the perfect time
They're
to
coming around right now.
receive a packet. So obscene materials are found in our schools, school libraries, in two ways. Physical books. I even have librarians asking me for help. She says they receive books from other sources. They are expected to put these books up. They read the books. They find that they are highly offensive, so they put them in a different restricted area. And the the media center personnel is constantly checking out this book so the kids can't read it. And she is asking for help. You're also going to see obscene materials in the online media center databases from third-party providers called EBSCO and Gale. And just last week, EBSCO was again listed on NCOSE, who stands for the National Center on Sexual Exploitation, listed on their Dirty Dozen list for providing these materials to minors. I have ability to show you on a screen, but I don't have that screen capability right now. So when you go through those, first you're going to see support letters for this bill. Support letters from a former state school superintendent, a school attorney, a current and former state school board members, current school superintendents, a judge, teachers, and parents who support this law. However, it's very hard to find current school personnel to sign on to support something like this because they are afraid of losing their jobs. So the problem is right now we have absolutely no standards. So for the library books, I'd like to read you an excerpt from a middle school book. From 6 up, I used to kiss other guys in my neighborhood, make out with them, and perform oral sex on them. I liked it. I used to love oral, and I touched their you-know-whats. We were really young, but that's what we did. In this book, there is no explanation that this is highly illegal. There's no explanation of getting this child any help. High school books. She clawed at Mac's back to bring him closer. Yeah, he groaned, and he pushed her thighs apart, and then suddenly Matt was inside her, pumping so hard that she scooted back towards the carpet, burning her back, the backs of her leg. Wait, Josie says, trying to roll away from beneath him, but he clamped his hand over her mouth and drove harder and harder until Josie felt him come. Sticky, hot semen pooled on the carpet beneath her. Again, no explanation that this is illegal. For some reason, in the last about 10 years, we have had a rise of erotic novels and literatures coming into our school libraries. Next one, page 290, and this is about in every school that I looked at. Every school has parents have asked me this, so I teach them how to look up these books. This book is in almost every school. I kept begging him to stop, but he just smiled and said he was going to fuck me up the ass. This is unacceptable. The next thing you will see is that EBSCO goes around the school filters. This is the media databases, so I just covered school library books, physical library books. The next portion is going to be how EBSCO goes around the school filters, and it goes around the home filters. And these are fully downloadable e-books that the child can have for free with taxpayer dollars. And again, EBSCO knows this is there. And so does the Department of Education, so does the legislature from last year. So then you'll see the searches for EBSCO, which are definitely the most egregious. If I could wave a magic wand and put EBSCO on notice that Georgia is a zero tolerance for obscenity to our children, I would wave that wand right now. So you'll see the first book the children told me about. I was teaching 14-year-olds in 9th grade, and they told me about this book called Swing, fully downloadable. And you can see that they are orgies. No one is wearing contraception. Next books, you'll see Porn Chic. Children as young as 11. One of the passwords from the mother, her password, she's 11 years old, her password is Tinkerbell, and she can fully download all this. And we have steamy romantic novels. So these, and the next ones you'll see rape porn and torture porn. And I hesitate, I do not use the word pornography because it's not defined. Obscene materials are defined in our Georgia law. If you look at section 101, it already says that we have said in our Georgia law that this is obscene for children and we need to protect them from it. So I urge you to read section 1612-101. It's very important. And you're going to hear testimony that we want to get rid of all books or that we're book burners. That's absolutely not true. There are obscene, fully obscene books that need to be removed immediately. And I just don't know any other way to do this but come here. We've tried at schools. You're going to hear testimony from parents who've been intimidated, ostracized. And it's very hard for a parent to do this. It really is. It's hard for a child to say, Mom, look at this book. They have to be brave enough to do that. And then the parent has to be brave enough to go to the school just to get knocked down because they heard somebody 5 years ago tried. We really need legislative help. Thank you.
Thank you. And as you shared some of that here, I mean, I can tell you, I'll speak that when we met about this bill, there's obviously stuff that kids get access to that I don't think anybody would support. And obviously there's an issue that needs to be addressed. And I appreciate you bringing the bill because, as you said, you've tried this before and haven't been able to get anywhere. And so I appreciate you bringing this to our attention. And one of the things that I discussed with the author is making sure that we have a way to really decide what is obscene. And obviously the stuff you share, I think we all would agree would fit there. And then a process to make sure that we actually do have a way to have this stuff removed and it can be removed. And I think that's part of what you guys have been discussing in the back here before we got started, is making sure versus just putting in the code here, we actually have a process for this in play too. So I just want to say thank you for the work you've done and bringing this to our attention.
Thank you.
Any questions from the committee at this time? Okay, thank you. And Cole Muzio, you want to be heard on this as well, if you want to step up, Cole.
Yeah, thank you. I appreciate it. And that testimony, probably more than most that you'll hear, speaks for itself. It's pretty haunting to hear that stuff is in our schools, and I hope that as you hear that, there is a consensus in this committee and that there's unanimity that is a problem. That our kids would have access to that, the ability to read that, the ability to see that, exposed to that at taxpayer expense and at our schools. That should be as close to a consensus position as we can find in this chamber. And as the chairman just mentioned, there's a process. There are some things that we want to work out. No one wants to put Miss Mabel, who's a third-generation librarian at the school, in jail. Nobody wants that. Nobody wants educational materials that are educational content and worthwhile content just thrown out. This is not about burning books or throwing people in jail, but this is about protecting our kids. And so there is some language being worked on to clarify some of those things and work that out. But this should all be something that we act on with urgency, with clarity, with decision, with a place of getting to yes, of how do we pass this bill right now, this session, moving forward, so that these kids that there's a mechanism in place to protect them. And so I appreciate the consideration of this committee. I appreciate your deliberations. I appreciate suggestions that you may offer to the language of this bill as we try to work it through, because this is urgent. The kind of things that you just heard in testimony that our kids have access to, that can ruin a child's life. And so we want to be very careful. We want to be intentional and act swiftly. And so that's my encouragement to this committee, is to find that consensus position, to put things in place, and to shape this language moving forward. So thank you.
Any questions for Mr. Muzio? All right, thank you. We have Mike Griffin here now with the Georgia Baptist Association.
Thank you, Mr. Chairman. My name is Mike Griffin. I'm a public affairs representative with Georgia Baptist Mission Board. Appreciate this opportunity to speak in favor of this important legislation. We really do appreciate the Senator bringing this before us today. As Georgia Baptists, we represent over 1 million Georgians and up to about 3,600 churches, and we're very much a part of trying to do what we can in dealing with sexual predators and all those things that are going on, unfortunately, in our state. We're the only state, we're the only denomination that supported the Hidden Predator Act back in 2015, and we still support that legislation and looking at entities as well. And I know that's not what this is about. My point is that we're all about victims and making sure that we're there to minister and to help and to care for them. But the old saying is, an ounce of prevention is worth a pound of cure any day. And in my work with dealing with child protection policy in churches, one of the key ways that sexual predators work on our children are through the grooming process. And part of that grooming process is showing them obscene materials. And the Lord knows that our school system doesn't want to be a part of grooming children for sexual predators one day unintentionally like this, or grooming them for the sex trafficking industry because they're growing accustomed to seeing these types of things and seeing these types of images. So it's not just important for us as Georgia Baptist and as the legislature to be a part of victim assistance and pulling people out of the river, but sometimes it's important for us to go up the river and find out where they're falling in at. And there's no doubt that access to obscene materials puts children in a position of a greater detriment, things that they should not be seeing or experiencing at that young of age. So we appreciate the committee's favorable support of this legislation, and we're willing definitely to work with amending it in any way that would make it absolutely the best. Thank you, Mr. Chairman.
Any questions for Mr. Griffin? All right, thank you very much.
Thank you.
Ms. Galloway, do you want to be heard as well?
Thank you for giving me the opportunity to be heard. I'm Virginia Galloway with Faith and Freedom Coalition, and we support this legislation. I was going to start by saying happy Dr. Zeus Day, because that's what today is, but he's just been canceled from the schools and from the libraries, and they're not even going to print their books anymore, is what I heard on the radio this morning, because they said that they're racist or something, which I don't really get. But this is a whole different ballgame than that, and yet that's what is being addressed right now, is that Dr. Zeus books instead of what we heard this morning. I think we have a really serious responsibility here to protect our children. Sure, people have a right under the First Amendment to publish things or not publish things, but we also have a responsibility to protect our vulnerable children. And so we support this legislation. As a parent and a grandparent, I love books. I was the nerd of my school library. I loved going to the library. I was best friends with my public librarian too. I went there all the time. My mom owned a bookstore. Books are great, generally speaking, but books influence your life. They have an effect on you. And so I don't think we get rid of everything that makes us a little uncomfortable, but I think as defined in Georgia law, obscenity should not be allowed in our schools, and our school libraries should be a safe place, including the databases that they employ for our children. They're already able to shield and protect children in the younger grades, so EBSCO and those kind of organizations should be able to extend that same protection to the older students.
Any questions for Ms. Galloway? Thank you.
Thank you.
We have Gretchen Walton with the Cobb County Schools here.
Are you planning to have a comment tomorrow? Because I'd rather speak to the changes in the bill.
Do you want to come on up just for a second here now? We've got to get a sub before we can hear this tomorrow, I guess. So I'd rather go and take the testimony now while we're all here if you can. Obviously, you can't address what may or may not be in a sub, but
Right, and I met with the group, so I do think there are going to be some changes. Part of
Okay.
our discomfort, I am sorry, y'all, I'm not going off my written because we have met.
Yeah.
I will say our first issue is where in the code they are asking to have the change. We're sitting in Title 16 rather than Title 20, which seems to be the inappropriate place. This really should be pretty soundly in Title 20. And so that was one of our issues. Some of our other issues, really looking at our media centers and the fact that they really are media centers, right? So there are computers in every one, and the way that the code's written, and one of the things I shared is there's a clause that talks about knowingly, and then there's a bunch of other stuff, and there's an or, and just it's very legally ambiguous, and I'm sorry to get in the weeds with this, but I do think you should look at it when you get whatever the sub is and look further. It is very concerning to us, and it's why I did suggest that they look at Title 20 rather than Title 16. They're going to say they don't want to criminalize this for our school personnel, but I mean they're sitting pretty squarely in 16 versus 20, so I think the intent is a little questionable. Some of our other concerns, we have a celebrated partnership with the public library where our students have access, due to being students in Cobb County schools, to public library cards. Just by being a student in Cobb, you automatically have a public library card, which we think is wonderful because it gets books in kids' hands and gets some reading. The way that this currently, they're just striking out the word school, but public libraries are still exempt, universities, colleges. Again, it's a problem with where it is right now and who they're asking to take care of the problem all by themselves, right? Schools, and obviously, we don't control EBSCO. We don't control, there's a whole number of people they name that are outside of our purview and outside of a media specialist who's curating a book collection, right? So I've condensed what I had to say. I would love to see the sub and have an opportunity to speak specifically to the language, but those are the bottom line of why we came today and why we are concerned as a district. We are concerned about where precisely and who precisely is going to be holding the bag on some of this. We also have, the other piece you need to know, we have a 7-page media programs policy that we have now shared with all these folks that just spoke. In it, 3 of the pages are the review process and how a parent can go to the school board, not the school principal, it's at the board, and actually get things removed if they believe that they are not appropriate. So we have a very robust process in our district that we hope other people would look at.
Ask you a question on that.
Of course.
Have you discovered in the conversations with the other people that there are things that students have access to in the system you work in that need to be addressed?
So nothing has been cited to me directly for my school system.
Okay. And in the event there is something that is found basically in the online version of the library, is there ability you guys have to actually filter out what the kids will see through that online forum as well?
So we have really strong firewalls and filters. You're asking me a question that's a little outside of my, I'll have to get an answer for you.
That's fair.
Because if it's privately curated, and then we would actually probably have to have a vendor fix the filters and the firewalls if it's privately curated. That is part of my concern, is that they're asking us to control things that potentially are not in our control.
Okay, so that would be in the control potentially of the vendor.
Of a private
itself.
vendor or third-party strategic partner, yes.
Okay. Any other questions for Ms. Walton? All right, thank you.
Thank you for your time.
Thank you. We also have Ms. Grace Kim here from the Georgia School Board Association.
We wave.
You wave? Okay. No one else has signed up to speak on this.
She didn't know how to sign up.
Okay, come on up and tell us your name. Sorry.
My name is Jennifer Cartier, and I am a mom who, a concerned mom over a book that my son had to read in school. Thank you so much, by the way, for listening to our plea. We appreciate your time, senators. Okay, I'm going to just read this. So my name is Jennifer Cartier. My husband was supposed to be here, but he had to be with his mom, who's in the hospital. I am a wife and mother of 3. I help my local high school by volunteering and substitute teaching. I testified last year about the need for this bill. Shame on the Department of Education for knowing about this problem and being silent for a whole year. I will return every year until this issue is corrected. We parents need this law. I followed all the rules and was still not able to protect my children. First, the children are victimized by reading these books, and even if they are brave enough to go to their parents, the parent complains about the book, and then the parent is isolated, victimized, and humiliated by the school. Here's what happened to us. I was appalled at a book my child had to read in high school. I complained about the mature graphic content. Now, this book has a lot more than what is about to be read, but I am going to defer to Noelle to read this part for me.
Why am I the expert reader of this garbage?
Could you mind sharing what the book is?
This is we have so many parents and so many books. This is The Handmaid's Tale. I can tell. My red skirt is hitched up to my waist, though no higher. Below it, the commander is fucking. What he is fucking is a lower part of my body. Serena Joy grips my hands as if it is she, not I, who is being fucked. as she finds it either pleasurable or painful, and the commander fucks with a regular 2/4 marching stroke on and on like a tap dripping, as if he's somewhere else waiting for himself to come, drumming his fingers on the table while he waits. There's an impatience to his rhythm now, but isn't this everyone's wet dream, 2 women at once? And I might add, this book is now a graphic novel, which comes in cartoon form, much more accessible and wanted by kids because it's in a cartoon form.
I want to add, too, there are scenes that depict women who are sexually mutilated and depictions of S&M. Okay. So I complained to the school and had to appear before a panel to hear my plea. My husband was out of town, so he couldn't be there. I brought some supportive friends who wanted to speak before the panel as well. Many parents had already sent emails to the principal opposing the graphic content of the book. I also had letters from parents who could not attend but wanted me to read them for them. Anyone who opposed the book was not able to speak, and they were removed from the media center where the meeting was held. Not only they couldn't be anywhere in the media center, and they shut the doors. I had to defend my viewpoint, family values, and my rights as a mother and taxpayer, 12 against 1. The handpicked panel included staff and 2 parents. I sat and listened as 9 of them spoke for their allotted time against me, and then swiftly voted against protecting our children from the book. Mind you, I had done so much research, even including how it did not pertain to the ACT or the SAT. It was not necessary. And what I realized is it didn't matter what I had researched, how much time I had put into it, the decision was already made. My son was told to pick a different book, insinuating our family was the problem and we were the troublemakers. Now, in this class, they spent an entire month going over this book. So that meant he would have had to have been ostracized and leave the class. He just would have been separated, and I don't think that's healthy for any teenager. If this wasn't bad enough, shortly after, a staff member decided to boast publicly about her victory in an online article. She simultaneously used her platform to malign, insult, and debase parents along with anyone holding religious beliefs. In the article, she said, quote, "Don't judge a kid by their ignorant parents. Out here in the north burbs of Atlanta, sometimes I get a kid who is forced to opt out of an excellent book because their parents are full of religious malarkey." She said they took great pleasure in voting me down. So even when you follow the rules to try to protect your children, they collude against you and humiliate you and your child in public to dissuade and intimidate other parents from doing the right thing. I grew up in Arizona, and my family there doesn't have this problem. Their schools protect their students and parents. This has got to stop, and we must have your help. Thank you so much.
Thank you. Which school system did you say that was in?
Fulton County.
Okay. You have a question, Senator Parent?
Quick question, you may have mentioned this. What grade was your son in when he read Handmaid's Tale?
11th. But there were 10th graders. Anybody could be in that class.
Thank you.
Okay.
And just to make sure I understand, that your situation was a physical book that was part of a reading list. It was also in the library and available online,
Correct.
I'm assuming? Okay.
Correct.
Thank you.
Required reading. Mm-hmm.
Okay. Any other questions from the committee? Okay. No one else has signed up to be heard. Did I miss anybody else?
I have a video testimony, but I can send it to you all. It's another mom that had the same issue.
Okay. If you want to send that to all the committee members or to my staff, we can get all our committee members so they can watch it later today after the hearing. Senator Anvatarte, if you want to come back up. You are still working on a substitute you want to present to us potentially for tomorrow, is that right?
That's right.
Okay.
Yes, Mr. Chairman.
And it seems like the challenge is going to be I think it was Ms. Walton said, we got to make sure whatever we do can actually be enforced. And so I think you can have those conversations about making sure that people that are actually in charge of this are the ones that we are providing guidance for in this, whether that be setting up this appeal process in every district that's fair to everybody, But we got to make sure that this local systems can actually make these decisions when they are considering it too.
Yeah, may I comment to that,
Please.
Mr. Chairman? I mean, I agree with you. I think I will just tell you from experience, having worked with my local district on hard issues, that if the local districts want to fix this issue and address this issue, we can do that to where it's transparent and the staff and teachers and everybody's kind of educated on what's going on as we would do anything else. I would take issue to what the lobbyist from Cobb County Schools said in relation to trying to criminalize. I mean, my wife works for a school district, and I would find it hard that I would be standing here today trying to criminalize what she's doing in her role. So I think that's quite frankly ludicrous. But I think parents at the end of the day know what's best for their kids and their families. I know teachers do, and having worked with them for so many years, that I think we can get there and make this, pretty common sense and not so difficult and overbearing that the school districts can't implement this, whether you're in a large county or a small county. So thank you for the time.
Yeah, thank you. And last comment for me, like we have to do a lot of stuff, we're balancing the idea of the local control of a locally elected school board that can be held accountable for their decisions versus needing some uniform standard in all of our districts around the state. So I will hold on the bill on taking any votes and see if you get us a substitute. And we are currently scheduled for 10 a.m. tomorrow in this room for another hearing.
Yes, for sure.
So,
yeah, we want to build that flexibility in so the locals can have a say in kind of what's going on with the process when these complaints come forward.
Yeah. Thank you. And thank you to everybody that's working on this bill. Appreciate y'all coming together.
Thank you, committee. Thank you, sir.
Thank you. Members of the committee, we can continue to move forward. We have two more bills on the agenda as soon as Senator Kauser gets back. Would y'all like to take a little break, or do you want me to keep moving forward? If anybody wants a break, I'll take it. Let's take a 5-minute break. Let's take a 5-minute break at least. It'll probably stretch to 10. Senate Bill 171. We have Senator Robertson here. Let me he has brought us a substitute to Senate Bill 171, and it's 413038S. Is that correct?
Yes, sir, it is.
Okay, the floor is yours.
And if I may start out thanking to my strong supporter to my left. My office was invaded during producing this bill, and the evil Dr. Scrivener came in. And if you will look on line 122 on page 6, where that sentence starts with no, it should start with any. And
where are you again?
Line 122, page 6, Mr. Chair.
So you want no to be any?
Yes, sir. And if you read the sentence with the any in place, you'll see that it makes much clearer.
Line 122.
Correct. Yes, sir.
Is that the only change you're going to ask us to make?
It's the only one I'm going to ask for, Mr. Chair. If the committee has any recommendations, I'm more than willing to listen.
All right, go ahead and tell us about the bill. Senator Parent, do you have an initial question? Hold on one. There you go.
It seems to be missing a page, Mr. Chairman. Mine ends at,
Which page are you missing?
well, I don't know how many more there are, but mine ends at line 215, page 9, and so it cuts off in the middle of the sentence.
So does mine. Probably everybody's is that way.
Yeah,
How many
I
more
actually
pages?
have 10 and 11 on mine.
So it's 2 more pages we're missing?
Yes, sir, it looks like it. I don't know how that happened. I know it was forwarded over to staff.
We will work on getting the copies of the other 2 pages, and we'll see if the committee's comfortable moving forward once we see what those are. If you'll go ahead and still tell us about the bill while we're waiting on that.
Mr. Chair, for the opportunity to come before you guys and your committee with this legislation. Judiciary Committee holds a special place in my heart. Graduated from high school and I weighed 128 pounds and was fairly strong. I decided I wanted to get stronger, so I found the meanest, ugliest, rustiest gym in Columbus, Georgia, Oates Gym, to join. And I got a whole lot stronger and now weigh close to 200 pounds. And when I go to Judiciary, I feel like I'm joining Oates Gym all over
Let's
again.
just talk about the bill. We're still late for the jokes today,
when
to
I
be honest with you, Senator.
Come out, I feel a lot stronger.
Yeah, I didn't laugh. All right, tell us about your bill.
I think what we're talking about is some very serious changes to law. I think the Supreme Court of the United States has held that the First Amendment strongly protects the right to conduct peaceful public assembly. But that right to assemble, however, is not absolute. Government can impose restrictions on time, place, and manner of peaceful assemblies, so long as they are justified without reference to the content of the regulated speech, and that they're narrowly tailored to serve a significant governmental interest. And I contend that a significant governmental interest is not only the protection of the citizens that live in the community where the assembly is held, but also to every single business owner, private property owner within that city too. And so knowing that, I felt that it was necessary after witnessing things that occurred in Seattle, Portland, Atlanta, and recently in our own capital, that maybe it was time that we looked at and redefined what peaceful assemblies were, and we defined what non-peaceful assemblies were. So in Senate Bill 171, what I've done is I've addressed several issues within there, and I'll start, if everyone is comfortable with it, I'll start on line 25 in section 2. And it says Title 16 of the Official Code of Georgia, annotated relating to crimes and offenses, is amended by revising subsection B of and adding a new subsection to Code Section 16.523 relating to simple battery as follows. If you jump down to the, I believe that's line 31, it says, if the offense of simple battery is committed while also violating Code Section 16.1133, other than as provided for under subsection E of this code section, the defendant shall be punished for a misdemeanor of high and aggravated nature. Go down to section 3, where I'm addressing also 16.1133 as related to unlawful assembly. Starting at line 38, as used in this code section, the term public convenience means, and below there are a listing of public conveniences, and everyone should have a total of 12. And then on subsection B on line 61, except as provided for under subsection C of this code section, a person who knowingly participates, and I'll repeat, a person who knowingly participates in any of the following acts or occurrences is guilty of a misdemeanor. And we go into what the Supreme Court in many states have identified as, in some cases, riots, and in other cases, assemblies. The assembly of two or more persons for the purpose of committing an unlawful act, and the failure to withdraw from the assembly on being lawfully commanded to do so by a peace officer, and before any member of the assembly has inflicted injury to the person or property of another. And I think an important part of that is the before question, which is already in Georgia law. And then we go over to the next page, page 4, starting at line 68. The assembly of two or more persons without authority of law for the purpose of committing violence against the person or property of one supposed by the accused to have been guilty of a violation of law, or for the purpose of exercising correctional or regulative powers over any person by violence. And Mr. Chair, what we did, if you, as we read through that, that it shall be an affirmative defense to a prosecution under this paragraph that the accused did withdraw from the assembly on being lawfully commanded to do so by a peace officer, or before any member of the assembly had inflicted injury to the person or property of another. And I think that change there is important because it gives those individuals who, once they are requested to withdraw from an unlawful assembly, and they do, then it gives them the opportunity to go to their vehicle, go wherever, and leave the unlawful assembly without any arrests or any penalties. And then on line 76, we've added the section, the assembly of two or more persons who convey any threat that is specific, indicates imminent physical harm, or threatens to alter the lifestyle or quality of life of the threatened person or his or her family members within any public convenience. A person who knowingly participates in the assembly of 7 or more persons and who commits violence against the person or property of another within such assembly shall be guilty of a felony. Upon conviction thereof, shall be punished by an imprisonment for not less than 1 or more than 5 years, or a fine of not less than $1,000 or more than $5,000, or both. And then on 84, there shall be a cause of action for injuries and damages against the governing authority of any county or municipal corporation that is grossly negligent by allowing the commission of violence against persons and property during an assembly of 2 or more persons. We move down to section 4. The change there on line 92, except as provided for under subsection B of this code section, and it goes on to identify a person who without authority of law purposely or recklessly obstructs a highway, street, sidewalk, or other public passage in such a way as to render it impassable without unreasonable inconvenience or hazard, and fails or refuses to move the obstruction after he or she receives a reasonable official request or the order of a peace officer to do so, is guilty of a misdemeanor. And then the added portion starting at 98, a person who violates code section 161133 while purposely or recklessly obstructing any highway or street in such a way as to render it impassable without unreasonable inconvenience or hazard, and fails or refuses to remove the obstruction after he or she receives a reasonable official request or order of a peace officer to do so, shall be guilty of a felony, and upon conviction thereof shall be punished by an imprisonment of not less than 1 nor more than 5 years, or a fine of not less than $1,000 nor more than $5,000, or both. On 105, it shall be an affirmative defense to the prosecution that the accused caused injury or death to a person while such person was acting in violation of paragraph 1 of subsection B of this code section, and the accused was attempting to flee such unlawful assembly under the reasonable belief that fleeing was necessary to prevent or terminate an attack upon the accused property or person. Mr. Chairman, we go down to section 5. We identify the racketeering activity of the unlawful assembly, which to mean shall also mean to commit, to attempt to commit, or to solicit, coerce, or intimidate another person to commit any crime which is chargeable by indictment under the laws of this state involving unlawful assemblies in violation of code section 161133 or any other law. And then we move over to the section where we had the Scrivener's error at 122, and a reminder that the no should now be an any. In section 6, the change there says no governing authority or county of a county or municipal corporation that within any one budget year reduces the budget for any law enforcement agency by 30% or more shall be subject to the withholding of any state funding or state-administered federal funding. And then 36-60-29 is a all new language that was placed in. Each governing authority of the county or municipal corporation shall establish and maintain an application process for the granting of permits to hold assemblies, including but not limited to protests and rallies on public property. And no such assembly shall be allowed without the granting of such permit. Such application shall be reviewed by an attorney representing the governing authority and by all public safety and public works department heads of such county or municipal corporations. All organizations, clubs, nonprofits, and individuals who apply for a permit must provide the names, addresses, and contact information for all individuals responsible for managing and maintaining order during the event, along with an emergency action plan that addresses any first aid and or security resources provided by the applicant. The governing authority of any county municipal corporation shall not require a fee for processing any application seeking a permit to hold assemblies, including but not limited to protests and rallies on public property, but may require liability insurance purchased within the state of Georgia to cover any potential liabilities. All applications shall be processed, approved, or denied within 10 business days from the date of submission. Any denial of permitting shall be accompanied by a written explanation from the governing authority of the county or municipal corporation as to the reason or reasons why the application was denied. Reading on line 144, the governing authority of a county or municipality that intentionally obstructs or interferes with the ability of a law enforcement agency of such county or municipality to provide reasonable law enforcement protection during a riot or unlawful assembly shall be civilly liable for any damages, including but not limited to damages arising from personal injury, wrongful death, or property damage approximately caused by the agency's failure to provide reasonable law enforcement protection during such riot or unlawful assembly. The sovereign immunity of each county or municipality is waived for liability under this code section. And then in Section 7, we identify, again, first responders and others. And in Section B, it states that the state of Georgia and the governing authority of every county and municipality that currently provide electronic payroll deposit to employees shall also provide payroll deduction to any full-time or part-time public safety employee who requests such a deduction for the purpose of purchasing insurance that provides such public safety employee with legal representation during all civil, administrative, or criminal actions caused as a result of his or her role or responsibilities as a public safety employee. Such electronic deduction may only be used to pay the premiums on insurance plans that are compliant with current ERISA standards and any dues or fees required by any professional organization that owns or provides such ERISA compliant product as a benefit of membership. And now over on page 9, and over here on page 9, we're dealing with Title 50 of the Official Code of Georgia. If we go down to 195, it says the part we added was except as provided for under subparagraph B of this paragraph, it shall be unlawful for any person, firm, corporation, or other entity to mutilate, deface, defile, or abuse contemptuously any publicly owned structure, monument, or cemetery located, erected, constructed, created, or maintained on real property owned by any agency or by the state of Georgia. No officer or agency shall remove or conceal from display any such monument for the purpose of preventing the visible display of the same. A violation of this paragraph shall constitute a misdemeanor. Any person who violates Code Section 161133 while mutilating, defacing, defiling, or abusing contemptuously any publicly owned structure, monument, or cemetery located, erected, constructed, created, or maintained on the real property owned by any agency of the state of Georgia shall be guilty of a felony, and upon conviction thereof shall be punished by the imprisonment of not less than 1 nor more than 15 years, or a fine of not less than 1,000 nor more than 10,000, or both.
And Senator, if you'll tell us what you're doing in sections 9, 10, and 11, just walk through those for us.
Yeah. And basically in 9, and I was wanting to make sure everybody has the pages now.
Does everybody have the pages now? Okay.
Yeah.
Just tell us what you're doing in the sections, because we can hopefully read it.
That's what I was trying to do. I knew y'all had just gotten the update, so I didn't want to leave anything out and make it seem like I was trying to ice over something. In section 9, we're talking about, and it helps here if I just the exercise or performance of the failure to exercise or perform discretionary function of duty on part of the state officer or employee, whether or not the discretion involved is abused, unless the exercise or performance of the failure of such discretionary function or duty is a violation of subsection D. This is, again, we're requiring that all officials do the job that the taxpayers pay them to do. And section 10, we've added a full section from 502138. The defense of sovereign immunity is waived as to any claim or counterclaim, cross-claim, or third-party claim brought in courts of this state pursuant to subsection D of subsection 161133 by the aggrieved person seeking relief. This code section shall not be construed to alter or amend any other waiver of sovereign immunity provided by law. So we understand that it's very specific what this would apply to. And if we jump down to 11, what we've provided there is many times during these unlawful assemblies that tend to lead into riots and other disturbances, that a lot of volunteers come out in hopes to assist nonprofit organizations, whether they be first aid organizations or community response organizations or neighborhood watch groups or others. that volunteer to help protect portions of their community, if they are recognized by the municipality and the county, then if you jump down to, I think it's 237, a volunteer during assemblies acting within the scope of his or her duties as provided for by the county or municipality shall be entitled to immunity as provided in Code Section 5111(9). Such volunteer during assembly shall also be immune from liability for good faith performance of his or her duties in accordance with the direction given by the county or municipality. And in the paragraph just above it, it basically identifies what those volunteer groups would be. And it would be a community emergency response teams, neighborhood watch groups, organizations that are registered with the Secretary of State and are designated under 501c8 or 501c3 of the United States Internal Revenue Code. And it also covers homeowners associations for those who step up to protect their neighborhoods.
Thank you. We have questions from the committee. Senator Kirkpatrick.
Thank you, Senator. I just, obviously I'm not a lawyer, and I'm sure the lawyers will have some questions, but lines 84 through 87, where it refers to a cause of action against the governing authority of any county or municipal corporation that's grossly negligent by allowing the commission of violence during assembly of 2 or more persons. I'm just trying to understand how they would know necessarily.
Basically what that applies to, Senator, is when it is known, and knowing it has to be a part of it, and they tell those agencies responsible, whether it's the fire department or the police department, to stand down. We experienced it last summer here in Atlanta when the Atlanta Police Department was advised by supervisors and city leadership to not arrest people, so that responsibility fell to the Department of Natural Resources, the Georgia State Patrol, the GBI, and others, because those officers had been told not to. And then during the fire that followed, I think a week or so afterwards, the apparatus that the city normally uses and deploys to fight fires was held up for 2 hours while waiting on approval to enter certain parts of the city in order to put the fire out. And so when those overt decisions are made by the government, then the government, according to this, then the government may be responsible for the liability, as opposed to the insurance companies who insure those properties.
Additional questions?
Just follow up, if I might. So, I mean, I guess I could think of some examples of how something unlawful, an assembly of 2 or more persons might occur without the knowledge of the county or municipality, but it doesn't really say whether they should know about it or not in that section of the bill. So.
And I think the weight in the court would be for somebody to have to prove that the municipality or the county knew about it and took no action.
Senator Jones.
My question along those same lines on 84 through 87. I understand what you're saying as far as the county municipality is concerned, but how about if you have a full-service sheriff's department? Wouldn't you be waiving immunity for that department because they are actually the governing authority in that situation for gross negligence?
I think you would if the sheriff came out and said, do not arrest anybody, do not enforce Georgia law during those times. I think the sheriff would step outside of his or her oath. Therefore, the qualified immunity rule that the U.S. Supreme Court has recognized, I think, sets up safeguards and narrow lanes that the sheriff and any other post-certified law enforcement officer must maintain. And I think if they consciously make the decision to not enforce Georgia law without good reason, and I think good reason if they thought it would lead to loss of life in certain situations or others, then I think that could be articulated. But yes, sir, Senator, I think you're correct.
Can I follow up, Mr. Chair? So my question, because the language now is just gross negligence, the immunity waiver or sheriff's department would not lose waiver based upon negligence principles under Georgia law. So that's what really gives me concern here.
And I think if you can identify an action by a sheriff's office or a police department, well, and the police department would be part of the municipality, that where the sheriff chose to where something he or she did was gross negligence, I think I could probably answer the question if you have an example.
I don't know if I have any examples offhand, but I just know that the standard is not negligence. Negligence doesn't alleviate a sheriff's office or a sheriff's deputy from that. You won't lose immunity based on negligence principles, and this, by saying they would be grossly negligent, would cause them to lose immunity. That's just very concerning to me.
I think the gross negligence comes at the beginning in the direction not to do the job. I think negligence, and you're absolutely right. I think negligence can unintentionally occur in a situation where maybe there's substandard training or something like that. But I think the gross negligence would occur when there's a direct order at the beginning to not do the job.
Okay, thank you.
Thank you, Senator. I appreciate you.
Thank you, Senator. We have a few people. You can hold your seat in case we have more questions for you. A few people that want to be heard on this bill. Make sure the right bill number. Larry Ramsey with ACCG. Mr. Ramsey.
Thank you, Mr. Chairman. Larry Ramsey with ACCG. I haven't seen the sub, but I appreciate Senator Robertson kind of reading through the specific provisions, and it seems to be substantively similar to what I've seen in the original when it comes to the provisions that I'd like to speak to. First off, I want to say what I'm not here to speak against, and that's, again, not speaking against adequate law enforcement and preservation of public safety. Georgia's counties are the primary provider and funder of public safety services in the entire state, whether that's through the 159 sheriff's departments, we have 13 police departments, 911 systems, EMS, fire departments, and when you consider the court system as well, more than half of county budgets go toward public safety in the state. So this is, from a county perspective, a core function, maybe the core function that we recognize and certainly hope to do the best job with that we possibly can. But there are several provisions of this bill that we have concern about. And again, not having the sub, I can't point you to a specific line, so I apologize, Mr. Chairman. But I do want to talk about some of the concepts. So one of the provisions has to do with budgeting. There's a provision, as Senator Robertson talked about, that would make counties ineligible for state and pass through federal dollars if they reduce their budgets by 30% or more for a law enforcement agency. Well, from one perspective, there's the protection that when it comes to sheriff's offices, counties have no choice but to adequately fund them. There's been decades of case law that say that we have to provide adequate funding for sheriffs to perform their functions. So as a practical matter, this protection is already there. But the bigger issue from a county perspective is who gets to make the decisions on what's the adequate way to spend county tax dollars. Just like people of this state send you here to make the tough decisions about how to budget county dollars, state dollars. The voters in each county have elected their county commissioners to make these decisions, and they're tough decisions about how you allocate scarce resources among the various needs that your county constituents need. And if you've served in local government, and even those obviously in the state, you hear from folks if they don't think that you're spending the money the right way. And if you make changes at the local budget, then those folks will likely, that the citizens don't like, then they are likely to vote those folks out of office. That's the appropriate remedy, whether it's law enforcement, whether it's how counties fund road systems, water and sewer systems, health functions. We believe that that function should be left to the county governing authorities, county boards of commissioners, in conjunction with their citizens as to how their budget should be set and should not be dictated, whether it's public safety or any other function at the state level. So that's one point I did want to make. Second is the liability piece, and to Senator Kirkpatrick's question that started part of that discussion, the discussion about gross negligence, et cetera. There are two parts of this bill that create new causes of action against counties. One of them is tied to gross negligence. I'm not completely clear on the wording of this language and how it would be interpreted, because it seems to say that gross negligence does in fact occur by allowing injuries or damage during an assembly. I don't know that that's the intent, but when it comes to negligence, as you know, and even gross negligence, there was some discussion about an intent to impede law enforcement on the front end. Well, gross negligence, ordinary and gross negligence don't look to intent. They look to whether a level of care was provided by the person that's being sought to be held liable here. The other cause of action, I think, does tie to an intent element, since it talks about intentionally obstructing reasonable law enforcement provision of services. What's reasonable? Obviously, that would be a matter of litigation, no doubt, that we would expect to see a lot of out of this. But at its core, we have a lot of questions about these causes of action. We, of course, don't like the idea of opening up the floodgates of litigation anytime someone is injured or property damage by an assembly of 2 or more people, because that's what we're talking about, 2 or more people, the way the bill is written right now. And so that doesn't say unlawful. One of the provisions talks about unlawful assembly, the other one does not. And so 2 or more people under this bill, if anyone is injured or property is damaged as a result of that, this seems to make county governments and other local governments a guarantor for the public for the safety and property damage protection, which is a dramatic change from the way the law currently stands. And obviously, open up those litigation floodgates, there are costs associated with that. The only other piece I would speak to, and again, thank you for the time, is the permitting requirement. As Senator Robertson talked about, there's a balance that has to be taken when you're talking about the rights of assembly and speech. Those are core First Amendment rights. And speaking from my personal experience, I can say that it is very difficult to thread the needle when it comes to a permitting scheme and the rights of assembly and speech, particularly when you're talking about what the law considers traditional public forums. So the sidewalks, the courthouse steps, et cetera. Those are core places where people are entitled to exercise these rights. And anytime the government is going to put a prior restraint on that type of First Amendment activity, such as a permitting scheme, it is very difficult to do, and this law would set up a eye of a needle that I think, particularly when you're talking about all the smaller counties and the lack of resources they have, it'd be very hard for them to thread, because they'd be balancing a requirement of this law to require a permit anytime 2 or more people want to assemble on public property with those constitutional rights. It's between the devil and the deep blue sea, because you're either going to be in trouble under the state law for not adequately setting up a permitting scheme, or looking at litigation before potential and alleged violation of constitutional rights. So we have a lot of questions and concerns about this bill. I'm happy to try to answer any questions. And again, thank you for your time and consideration today.
Thank you. Any questions for Mr. Ramsey? All right, thank you. We have Isabel Otero with SPLC Action Fund. Good afternoon.
Good afternoon. Thank you for giving me the opportunity to speak. My name is Isabel Otero. I am a policy associate with the SPLC Action Fund. SB 171 will undoubtedly trigger a variety of constitutional challenges. We ask that you please spare Georgia taxpayers this expense and vote no on this bill. Though I am not myself an attorney, I work with a team of civil rights attorneys who have reviewed this bill, and I'll be sharing some of their concerns. We know that a lot of our colleagues from other civil rights orgs have already provided testimony regarding, the expected First and 14th Amendment violations. And while we are also concerned with those, equal protection, due process, and freedom of speech and assembly, we're going to focus our testimony on something slightly different. And so the first thing I would say is that from our perspective, SB 171 seeks to target a very specific type of protest. This is a bill that redefines and expands key terms like unlawful assembly and riot. It is a bill that enhances penalties for those violations and then seeks to punish protesters for using specific types of tactics. And so, for example, Section 8 of the substitute prohibits damaging state memorials. And to us, that appears like a very transparent attempt at protecting Confederate monuments. There are already plenty of protections in the Georgia Code for this. Defacing or damaging a state memorial is also not particularly well defined in this bill. So, for example, without a clear dollar amount or a threshold for damage, you could potentially walk up to a statue of General Lee with some chalk mark it saying, you know, this Confederate statue is racist, and that could potentially get you 15 years and a very high fine, right? It's just not very clear. The bill also prohibits blocking of highways and public spaces without a permit, and as we all know, I think permits are designed to delay protests. So say there's a police-involved shooting, communities can't immediately respond to a tragedy, right? Like you're asking them to wait almost up to 10 business days. Our team, you know, beyond targeting specific types of protesting, the most worrisome part of this for our team is that this bill appears to invite violence by extremists at protests. So our team and our sister organization, the Southern Poverty Law Center, monitors and reports on violent hate groups and extremists. And it's really important to understand that for groups like the Proud Boys, for other violent groups, their entire organizing principle is violence. This is how they grow their ranks. This is how they fan the flames of their racist ideology. And over the past election cycle, we have seen an increase in extremist activity by some of these groups and some serious political violence. And some of the senators in this very committee have experienced violent death threats and other issues, right? So it's important that a bill like this not help out militias or extremist groups. And unfortunately, this bill gives some cover to those groups, right? Section 11 of the substitute extends immunity protections to volunteers, right? That unfortunately could mean private groups like the ones that we track that could effectively get immunity for doing the type of thing that they are often seeking to do, right? They're seeking to be violent, to provoke violence, to attempt to be an extension of law enforcement. Groups like, for example, the Oath Keepers, which are active in Georgia, they see themselves as this extension of law enforcement. It's part of the way that they work. This is the kind of protection that would basically allow these groups which espouse these horrible, hateful ideologies and have very different agendas from law enforcement to kind of volunteer with law enforcement. Another example is the substitute Section 4 creates an affirmative defense for people like murderers like James Alex Field Jr. And you might not immediately remember that name, but unfortunately, back in 2017, the country watched the images and heard the racist chants in the streets of Charlottesville, Virginia. They were from the Unite the Right rally, which prompted then countless of counter-protesters who felt the need to essentially stand up to this horrible display of racism. And one of those counter-protesters, Heather Heyer, she never made it home. James Alex Field Jr., who had a history of text messages, social media posts, first-person accounts, his own family tried to intervene because of his violent threats against, Jewish people, African Americans, essentially non-white people. He decided he would run over these protesters who blocked the street in Charlottesville. He killed Heather Heyer, and he injured at least 30 other people. So SB 171 would provide her murderer with a possible defense. And if Virginia had a law like this in effect, Field could claim that he had a reasonable belief that he or his truck might have been attacked. And this is the kind of behavior that we're unfortunately deemed to repeat here in Georgia if we allow a bill like this to move forward. And it's dangerous unintended consequences that I'm not sure this committee has considered. And so, you know, I'll close with this. I think that members of this body would agree that something like the civil rights movement of the 50s and the 60s, it forced great progress on this nation, right? It ushered in new promises of racial equality. It, it created new federal laws. There were some really important decisions that undid some of the Jim Crow segregation of the Deep South. And we have to remember that that wasn't created in a vacuum. That wasn't by accident, right? That required some protest. And while the protests that we all witnessed this past summer, for example, they may not seem like a continuation of the civil rights movement to some people watching, but those protesters have the same fundamental rights as students who organized lunch counter sit-ins, or as the late Congressman John Lewis, who walked across the Edmund Pettus Bridge in Selma, Alabama. These are the kind of collective actions that this bill seeks to criminalize, and those are the very actions that, that are required in order for us to confront the issues and injustices that people deal with every day. And so we really urge you to vote no on this bill. Respectfully, SB 171 really does look like the kind of Jim Crow relic that this body is trying to repeal in other places with the repeal of Georgia's citizens arrest law. So thank you. That's just trying to share some unintended consequences of a bill like this. Thank you for your time.
Thank you. If I have any questions for Ms. Otero. All right, thank you.
Thank you.
We have Chris Bruce with ACLU of Georgia, and is Chris here? Okay. Mr. Bruce, how are you?
Well, Mr. Chairman.
Yeah, there wasn't better things to do outside than to be in here, was there?
Oh, no, not at all.
And I'm not going to cut you off, just to let everybody know we do have another committee. We finally do have a hard stop for once at 2:15. Dr. Watson has a committee, so we're going to try to be out by 2. We still just one other person signed up to speak on this bill, so I think you have time. But I just want to let you know we have a little bit of a limit. But the floor is yours.
Well, thank you, Mr. Chairman. This is my first time in front of your committee, so thank you for having me. Thank you, Senator Robertson, for listening to this speech as I go into our constitutional rights. Again, my name is Christopher Bruce. I'm the political director for the American Civil Liberties Union of Georgia. This is an organization dedicated to protecting your civil rights and civil liberties. And some of your most vital civil liberties is ensuring we have a free and fair democracy and the civil liberties guaranteed under our First Amendment to the United States Constitution. This fight for freedom of speech has been the bedrock of the ACLU. Let me tell you, this has basically been in our DNA since day one, where we started with protecting the constitutional rights of conscientious objectors and anti-war protesters. The organization's work quickly spread to combating censorship, securing the right to assembly, and promoting free speech in schools. We have stood for these rights, even when people that we didn't agree with what they were saying, but knowing that they have the American constitutional right of free speech. So now, one of the gravest threats to our First Amendments are attempts to infringe on the constitutional right to freedom of speech and freedom of assembly and petition. Senate Bill 171 infringes on those rights in a number of ways that are dangerous and should be of great concern to this committee. We know that this tramples on our First Amendment rights, and that's where I want to emphasize. For incentivizes counties and communities to crack down on protests and or prevent them from occurring in the first place at all, and attempts to punish the municipalities for meaningful reining in the police when it really needs to happen. SB 171 seeks to scare people into exercising their First Amendment rights via lines, and excuse me about the substitute that we've had, lines 38 through 60, 76 through 78, which dramatically expands the scope of law criminalizing unlawful assembly. We're up here looking at how this looks into highway obstruction, referring to defacing public monuments, which ratchets up penalties for unlawful acts conducted during an unlawful assembly, as defined in this proposed legislation. SB 171 seeks to scare individuals into exercising their First Amendment rights by implementing a broad and vague definition of unlawful assembly. So throughout history, we've seen people who have suffered the gravest consequences when police are encouraged or permitted to take drastic responses in their interaction with civilians who are exercising their First Amendment rights, especially in the context of civilians protesting for justice and equality. Like we saw racial justice protests during the summer of 2020, like we've seen in the summer of 2016, and like we've seen since the beginning of this, the nation's founding. We'll continue to see civil rights movements that happen until we actually are all free at all times. So the right to join the fellow citizens in protest or peacefully assemble is critical in functioning democracy at the core of our First Amendment. And as legislators, you all have taken an oath to uphold and defend the American Constitution. And it is my hope on the behalf of the ACLU of Georgia and our members and supporters across this great state that this committee will not move forward with Senate Bill 171, especially in its grotesque nature of focusing on First Amendment rights.
Thank you, Mr. Bruce. Any questions? Thank you very much.
Mr. Chairman, with no questions, I'm glad that all of you agree with me. So,
I don't know.
See you next time.
Oh, yeah, fair enough. Ms. Causey, Maisie Lynn Causey with Georgia Association of Criminal Defense Lawyers is the last person on the list to be heard on the bill.
Thank you for hearing from me again today. Senate Bill 171 criminalizes lawful protest in violation of our Constitution, state and federal. GACTL typically doesn't weigh in on First Amendment matters, but when it's a subject of criminalization, we cannot stand idly by. Article 1, Section 1 of the Georgia Constitution, which is derived from the First Amendment of our federal Constitution, guarantees that no law shall be passed that curtails or restrains the freedom of speech. A few examples of how SB 171 does that. It expands the definition of unlawful assembly to include when 2 or more people harass or intimidate someone in a public accommodation. It provides for felony prosecution of someone who, while in a group of 7 or more, commits violence against a person or property, even if that conduct would otherwise be a misdemeanor. It creates a new felony offense for persons who obstruct highways or streets, persons who deface public monuments. I'm going to focus now on the aspects of the bill that most directly relate to the expansion of our criminal code. Because the behaviors targeted in SB 171 are already criminalized in Georgia law. Georgia law has several laws in the books that subject people to criminal prosecution for acts of violence while in the presence of other people. It includes riot, inciting a riot, obstructing a highway, terroristic threats, terroristic acts. Of specific concern to us at line 79 of the substitute bill, that an assembly of 7 or more persons is a penalty enhancement, will leverage lawful acts to support prosecution even when the targeted behavior is not a threat to that larger group. Georgia law already criminalizes groups organized with the purpose or intent to behave violently or illegally. We have party to a crime criminal liability. We also have the RICO Act, which is the Racketeer Influenced and Corrupt Organizations Act. When this legislature passed the RICO Act, the General Assembly made clear that the intent was not to prosecute as RICO violations isolated incidents of misdemeanor conduct or acts of civil disobedience. Instead, RICO was intended for an interrelated pattern of criminal activity motivated by, or the effect of which is, pecuniary gain or economic or physical threat or injury. It's worth noting that a conviction for a RICO violation is a felony and carries a criminal penalty of 5 to 20 years in prison with a fine of either $25,000 or 3 times the amount of the pecuniary value gained. I would also turn your attention to line 80. The notion of violence in line 80 of the bill is vague, broad, and contrary to the degrees of severity on which our criminal code is constructed. For example, we have levels of severity, starting with, say, assault. An assault is effectuated by mere words. A simple battery is effectuated by a touching. A battery requires visible harm. An aggravated battery requires the loss, even temporarily, of a member of the body. And then aggravated assault requires the use of a weapon. By not clarifying that notion of violence in line 80, this bill just draws in too many possible behaviors. We would also turn your attention to lines 202 through 209 and let you know that I'm at the risk of instigating further expansion of our code. I would let you know that in Georgia, you can actually steal a monument and you're only subject to 3 years of possible incarceration. This bill would have you serving up to 15 years merely for defacing it. And what does that mean? Writing on it with chalk? It's not clear from the language of the bill. Senate Bill 171 provides immunity for people who cause harm to protesters. Even as I stand here representing a constituency keen on expanding immunity from prosecution, I will admit that. We are often very happy to have immunity expanded. I cannot in good conscience abide what is laid out in lines 10, I'm sorry, my line numbers are probably off from the sub, but old line numbers 106 through 110. The scenarios that come to my mind when contemplating the situations that could give rise to this immunity involve motor vehicles and the possibility that someone could hit a protester with her car. We know from other protest fatalities in our country that people have used their vehicles as weapons against protesters. This portion of the bill seems to goad that appalling behavior with the promise of immunity. It is unnecessary. Georgia's self-defense laws, which also include the defense of property and the defense of others, provide ample protection right now for people who actually are defending themselves, their property, or another citizen. If you have any questions, I would certainly stand for them. That's all I have for the committee today. Yes, sir.
Senator Reck.
So basically you're saying that there's already statutes and laws that pertain to defacing a monument?
The one I was mentioning is actually about the theft of a monument. But yes, there would also be criminal damage to property. I didn't think about that one when I was preparing my remarks. But government property cannot be damaged under the law right now either. So we do have both criminal damage to property laws as well as theft laws involving state property, government property.
Thank you.
Yes, sir.
Any other questions? Thank you, Ms. Causey.
Sure thing. Thank you.
No one else has signed to be heard on this bill. Senator, we're going to hold on taking a vote at this time if you want to get members of the committee. And we do have one more hearing tomorrow at 10 if something else you want to say?
Well, just briefly, if I can, and one of the speakers made my point when she brought up Charlottesville. If you look at the after-action report on Charlottesville, the Charlottesville after-action shows that clearly it was the fault of the municipality and the law enforcement, public safety, that ended up causing the death and a lot of the incidents that happened there. With the ACLU coming in with their new mission of cherry picking when free speech is free speech and when free speech is not, I would have not expected any less of them. And to have the criminal defense attorneys come in and do theirs was no surprise either. Now, they seemed to focus on monument, but the only two words I added in there were structure or cemetery. And I think it makes perfect sense. And the Supreme Court has ruled many years ago in cases that have long been on the books, that you have a right to free speech, but you don't get to choose the exact place, exact time without allowing the government input. And with the permitting process, it allows all of those things to occur safely. And the majority of the incidents that we've had here around the Capitol have been very peaceful. But at nowhere has the Supreme Court ever said it was okay for anyone to block a highway, a road, or impede a citizen not participating in that protest the ability to move back and forth freely. And so while I appreciate the committee and I understand completely, this is actually a good piece of legislation that all we have to do is look at today and look at the past and the future we're moving into, and I think everybody understands the necessity for this, and I respect the chair's decision.
Thank you. I appreciate it. Thank you for your time today.
Thank you.
All right, we have one bill left, going back to Senate Bill 190. And we are on LC 364651. And I'm going to turn it over to you, Senator Cowser.
Thank you, Mr. Chairman. Get my notes together.
Read my pointer.
Okay. I promised you I'd keep this to 5 minutes if you'd let us hear it, and I think I can. We have heard this issue also in the past, and it's referred to colloquially as phantom damages. They're imaginary damages that people did not incur. To start with, Georgia law seeks to award compensatory damages to make a plaintiff whole, to compensate them for the injury done to them and for their losses, not to give them a windfall at the defendant's expense. Several items of damages are usually sought, and let's just use an automobile accident as an example. You can get any medical expenses that are reasonable in nature and necessarily incurred. You can get lost wages if it's a result of the injuries received in the collision. You can get future lost wages, future medical expenses, and you can also be compensated for your pain and suffering. In addition, we now have several processes where plaintiffs can recover attorney's fees in many instances. This bill seeks to prevent double recoveries or recovery of damages that were not actually incurred, and it's very simple the way it lays it out, that you may not seek damages that you didn't incur. And this only applies to medical expenses. You're limited by this new statute, starts there on line 8. I'm referencing line 12, that have been paid by or on behalf of the claimant, that's the injured person, to healthcare providers for medically necessary care, treatment, or services, or that are necessary to satisfy incurred but unpaid charges. So you wouldn't have had to already have paid it out. You can still seek damages if you haven't paid them yet for these medical expenses. And on the back page, it makes it clear that the defendant may still contest those charges if they're not reasonable and necessary. For example, if they were incurred in treatment for a pre-existing injury or something not caused by the collision, or if it was unnecessary medical care being given. So this doesn't interfere with that rule, and that in sum is what the bill does. I anticipate pushback because in the past sometimes the plaintiff's bar argues that this violates the collateral source rule. Collateral source rule is a rule of evidence that prohibits you from placing into evidence information concerning the fact that a plaintiff's medical expenses or other special damages have been paid by insurance or another third party. This bill does not impact the collateral source rule. It does nothing in this bill allows the defendant to introduce evidence that the plaintiff's medical bills have been paid by insurance. This simply says you can't seek to recover or introduce evidence of medical expenses that you did not incur or that were not charged to you. I think there may be a couple people signed up. I'm happy to answer questions or let them speak.
Any questions for Senator Cowser? Senator Kirkpatrick?
Thank you, Senator. Just to be clear, I used to practice medicine and can just agree with you that a charge on a charge master is a number that nobody ever pays, because the payment depends entirely on your insurance contract. And the people who are actually in the worst shape are the people who don't have insurance, because that right. is less likely to be discounted. So it's really has always seemed unfair to me that things are based off of charges rather than payments.
Yeah, that's the problem we're addressing. There is no relationship between that top line fee that a hospital or a doctor might quote and what they actually routinely accept, and in that case accept it as payment in full. So if you have a surgery fee for $100,000 but you accepted $30,000 as payment in full, it's unreasonable for the plaintiff to then seek recovery for the $100,000 when they only lost the $30,000 in medical bills. That's what this addresses. Thank you.
Senator Parent.
Woke me up. Good. So I have a question about that. So I'm familiar with the issue slightly as it relates to the charge master and the insurance contracts and everything. So, but I guess if this were a problem that insurance companies are aware of, like, oh, they're presenting us with the charge master, what's put on the charge master sheet, and that's what they're going off of. I mean, isn't it within the power of insurers and hospitals to adjust the way they present these things so that it's not, the charge master is not so wholly unrepresentative of what most people pay. I mean, I understand that uninsured people can get hit with it.
Right.
But you understand my question?
I understand it. I mean, this wouldn't hurt that uninsured person if they did have to pay the retail sticker price. They can present that in evidence.
Well, I understand that. I just meant like.
Well, you're not confusing, but you're conflating the health insurers and the liability carriers. You know, that's the health insurance companies are.
Yeah.
You know, they don't tell the insurance company how much. I mean, the healthcare provider how much they should charge. They just negotiate how much they will pay for those services. And of course,
Yeah, I understand that. I guess I thought that there could be sort of like industry discussion about
I wish there would
your
be.
practices are causing us all kinds of trouble if that indeed that is the case.
Some of our bills on billing transparency are addressing these gradually by making providers show what their charges are and what they accept, and it has ripples throughout all the other indigent care. You know, you've got hospitals claiming they're providing indigent care at the sticker price when they routinely accept much less than that as payment in full, but getting credit for claiming they're giving indigent care out. In the differences, and that's warping the system as well.
Mm-hmm. I am familiar with those other two issues, and I do support taking a look at those. Thank you.
Senator Hatch,
Thank you, Mr. Chairman. I have a quick question for Senator Cowsert. I know not everyone in the room is an attorney. We both are, for the sake of transparency. And this may seem like a trite question, but could you help explain subrogation as it relates to the made-whole doctrine in this state?
Yeah, I don't know about the Maypole doctrine, but if you're talking about subrogation from an insurance company, a health insurance company.
From a health insurance company.
Often they allow recovery from the at-fault party in a case to be reimbursed for amounts they pay in the event the claimant recovers from the defendant. So as that ties in here, if the plaintiff, as I would perceive this, were able to recover their actually incurred medical expenses, then their medical carrier might ask them to be reimbursed for the amount they recover in the case.
And would you agree that just about every medical insurance policy in the state of Georgia includes the language about subrogation for the made-whole doctrine?
I don't know, but if it would, they can only recover what was paid.
Correct.
And what was recovered. So that doesn't, I don't see where that impacts this. They couldn't go subrogate against somebody for the sticker price when they were only able to recover the actually incurred loss.
Okay.
And that, of course, would be the loss to that company trying to subrogate was what they paid out on the claim. They wouldn't be seeking a windfall either.
Right. So would the jury, when this bill, would you be open to an amendment that would allow the jury to know that the health insurance company, if they are to get paid, if they are to grant the plaintiff damages, that the insurance company is entitled to be paid back? The health insurance company is entitled to be paid back from the proceeds that the jury would award the plaintiff.
If you're willing to abrogate the collateral source document, I'm all with you. That would be great. You, of course, have to tell them that there was health insurance that had paid that loss.
Well, and Mr. Chairman, if I may, in an instance where I've had health insurance my entire life and I've paid all my premiums, and I don't know about you, but I mean, when I pay my premiums for my family, it's over over thousands of dollars, over $1,000, and I pay it every month, even if I'm a single person, and I've paid into this and I've never made a claim. And then when I do get injured, even if it is caused by someone else, then the insurance company is paid back for what they paid out. I think the windfall in this situation would be the health insurance company.
So you want to do an amendment to limit their subrogation rights? I'm cool with that. I mean, everybody has insurance now. You're required by the Affordable Care Act to have it. If you can't afford it, you're subsidized till you can. So, I mean, that's ought to be a very common situation.
So you'd be willing to make an amendment to do away with an insurance company health insurance company subrogation rights?
Sure. If that's you want to say that in this bill?
I mean, I'd like to open it up to a discussion.
I mean, if you're talking about limiting their subrogation rights to the amounts that were actually incurred, then I'm fine with that.
Oh, no, I think
sure.
That's how it is now. Because the made-whole doctrine is, if you get a verdict if a plaintiff gets a verdict, then the insurance company is entitled by law to be reimbursed whatever they paid on behalf of the plaintiff. So if it's a $10,000 bill that the insurance company negotiated down to $3,000, you're only allowed to put $3,000 in evidence. The jury gives it to you. You automatically give that to the health insurance company.
Yeah, I think what you're talking about goes further than just these rules of evidence. If you have a separate freestanding bill that does that, I think that would be a good debate to have, and I think everybody needs to weigh in on that. I've never been a fan of subrogation, and it doesn't happen that much, so I don't think it's drastically affecting, any kind of health insurance rates.
All right, let's let the people that are here to be heard on this bill speak. Mr. Thrash, did you have something, or was that? Okay, just making sure. I heard you call out a minute ago, so. Mr. Crowell, Ed Crowell. Yes, sir. Let me get your mic on. Okay.
If y'all are comfortable, I'll take this off for a moment. So, thank you, Mr. Chairman. I'm pleased to tell you that I figured out how to sign up this time, unlike the last time I was here. And I will be brief, but Mr. Chairman, I'd like to touch on just a few points, and one is that just the anachronistic nature of the current situation. These laws were put in place before there was health insurance, before there were in-network, out-of-network, and all those sort of things. And as Dr. Kirkpatrick already said, nobody pays the top line number. And so when you're allowed to walk into court and demand reimbursement for that top line number, you're essentially asking for money you've never spent. And you often ask, or the committee often asks, if other states are dealing with this. Well, many other states are fixing this law. Idaho, Michigan, Connecticut, Texas, Kansas, Oklahoma, they've all dealt with this, and they've all changed laws to address it. Texas as well, even Louisiana, and there's a whole long story about the frauds that Louisiana discovered and the people who are going to jail for committing frauds because of the temptation of hitting that top line number and asking for that to be reimbursed. And even the state of California has addressed this. And this is one thing I'll read to you really quick. This is the California Supreme Court. The injured plaintiff may not recover sums written off by health care providers for the simple reason that the plaintiff did not suffer any economic loss in that amount. So even the state of California, which I rarely hold up as an example to follow, has addressed this. This is simple and straightforward. And, at the end of the day, Senator Hatchett, if the insurance company paid out $3,000 and I have to give them back $3,000, I haven't suffered any loss because they covered the $3,000 for me. And I understand your point about premiums, but premiums are a bet. If you pay monthly, it's a monthly bet. I bet something bad will happen. The insurance company bets something bad will not happen. When I'm right, they pay me. When they're right and nothing bad happens, I lost that month's premium. I don't get it back. No insurance policy is based that way. But again, I want to be brief. I'll be glad to take any questions, but I do want you to understand that state after state is addressing exactly this problem. Because in any other aspect, to go in and ask for payment for reimbursement for money you never spent is actually unethical and fraud. And so there's no reason we should allow it in our court system. Thank you.
You have a question from Senator Hatchett?
Yeah, thank you for addressing that. How does a patient get the benefit of paying $3,000 instead of paying $10,000? And this is just in this hypothetical.
I would agree with you. There's not a particular benefit to the patient. The patient has insurance to cover that cost, to cover that procedure, if you will. And the insurance company paid it for them. So the patient's out $0 for that procedure. The court awards $3,000. That's not a windfall to the patient if, in fact, the insurance company chases them and says, we want our money back. The patient started out with $0. The $3,000 went through the patient's possession back to the insurance company, but the patient still paid $0 for the procedure.
I would respectfully disagree that the patient paid whatever their premium was that month to get that coverage. So they didn't start at $0. I think they started negative.
And I would just respectfully disagree that that's how the right way to view insurance. So,
thank you.
Certainly.
Any other questions? Thank you very much.
Thank you all. I ask you to support this.
Mr. Pope, still around?
I'm over here.
All right.
Over here, Mr. Chairman. Thank you. It's been a long day. I know everybody's ready to wrap up. I'll try to be as brief as possible.
also noting there is a lot I need to sort of touch on. A couple things real quick. Just to be clear, there was some mention of states working on this. Texas was one in particular. Texas still has the collateral source rule. There's a case, Weston versus AK Happy Time LLC, as recent as August of 2019. They still uphold the collateral source rule. So, and I counted in terms of states that uphold the collateral source rule. That's the current law in Georgia. It's almost 70% of the states. Now that's just one point. I will also, point out, and I didn't want to do it earlier, but I think it's important when we think about making drastic changes to our tort law that we constantly remind ourselves that Georgia has been ranked the #1 state to do business for, I believe, 8 years in a row. And you don't get that ranking without having a good, vibrant, healthy tort system where people and businesses are held accountable in courts of law with good judges. You don't get that. Senator Calcert does, and others have said, this does not affect the collateral source rule. I respectfully say that is not accurate in my opinion. Okay, it essentially guts the very purpose and essence of the collateral source rule, so that it would be effectively gone. Maybe that's a better way to say it. Again, as has been noted, this law will affect victims and limit damages that they can receive from a jury in Georgia. A victim who's been catastrophically injured or killed by the negligence or recklessness of another person or company has the right to make a claim for medical expenses, as has been noted. Our current law allows a victim to introduce his or her medical expenses to a jury. And this has been our law for almost 150 years. In fact, one of the first cases I read was a case in 1885, and it with respect, it did deal with insurance. Insurance was around and was discussed in that case. Evidence of what was paid to the medical providers, health insurance, Medicare, Medicaid, that's what's called a collateral source. And those have never been allowed to be discussed or introduced in a trial in Georgia. And likewise, the fact that the defendant who was negligent or reckless and caused the injury the fact that they have liability insurance is not admissible. Liability insurance is also considered a collateral source. And I will also point out, this has been, as has been stated, this is the third year in a row that this law has been proposed, this bill has been proposed, and it has not been voted out of the Senate at any of those times. And I think for good reason. That's because this body, the Senate, recognized in 2019 and 20 that this bill hurts victims, Georgians, and only benefits big insurance companies. If this bill passes, be very clear, victims will receive less. Conversely, big insurance companies like State Farm and Allstate, Progressive, Geico, others will have to pay victims less if this bill passes. And it will not, and it's not been said, it will not reduce auto insurance premiums in Georgia if this bill is enacted. So let's get back to, so when we talk about, when we say this bill will not affect the collateral source rule, the purpose, what is the purpose? You have to know how this will gut and the collateral source rule. You have to look at what is the collateral source rule? What is the purpose of the collateral source rule? Because as Senator Kirkpatrick mentioned, upon first glance, she said it seems unfair. But there is a purpose to it, because it balances out who should get the benefit in Georgia. Should it be the wrongdoer, or should it be the victim? So what is the purpose of this law that prohibits introduction of evidence that a victim has health insurance or Medicare or TRICARE? The wrongdoer should not and does not get the benefit of the innocent victim protecting himself or herself by purchasing health insurance. In other words, current Georgia law holds accountable the wrongdoer. If this bill were enacted, it would essentially be premium theft. The bill would take the health insurance benefits bought by the victims and give them to the people who hurt them. Health insurance benefits include discounts at hospitals and doctors' offices, and under the law today, the victim gets the benefit of those health insurance discounts. And we talk about this, let's fix the top line number. That would fix this problem. That top line number, the amount billed, is something that as you know, doctor and other, that is worked on, and your offices look at what others are charging, and that could solve this problem. Now, if this bill were enacted again, it would shift the benefits of the health insurance to the wrongdoer. If you or your loved one becomes paralyzed by a drunk driver, who should get the benefit of your being responsible and purchasing health insurance every month? Moreover, there will be a practical harm to responsible Georgians if this bill were enacted. Georgians who pay for the best health insurance would receive the least amount of compensation when they're injured. Georgians who don't pay for health insurance would receive the most amount of compensation under this law. So who would receive the worst result? Victims, who would receive the worst result if this bill were to become law? Military service members who have TRICARE, elderly Georgians who have Medicare, veterans who receive health care through the VA. They would all receive less if they were a victim and injured by a wrongdoer than those who don't have health insurance, who aren't responsible and don't purchase health insurance. Those people would receive the best results under this bill. Another practical problem is, and it's been discussed, is this idea of reimbursement. Okay, and to clarify, when you make a claim, when your client has health insurance and you make a claim for those medical bills, the health insurance will make a claim against your client for reimbursement. The client never gets to take that award. They have to turn around and pay back the health insurance. And I would respectfully say a lot of that is governed by federal law under ERISA, and I don't think it would preempt any state law on that as well. But if this bill were passed, and the only evidence that would be able to be submitted at a trial would be the actual amounts paid, the victim who was responsible in purchasing health insurance would effectively be working for the health insurance company, because they would submit only what the health insurance paid, and they'd turn right around and have to pay it right back to the health insurance company with no reduction for any amounts whatsoever. And that I don't think would be fair. There's also the issue of how this bill would affect future medical expenses. Someone who has health insurance and may have a permanent injury, somebody who's paralyzed, may have millions of dollars in future medical expenses. Well, there's no guarantee that this victim is going to have health insurance in the future. And any award based on what maybe health insurance might pay in the future, the second that person loses their health insurance, then how is that going to be fair to the victim? I think that I've made most of the points. I appreciate your time today. I know y'all have had a long day. Can I answer any questions?
Any questions for Mr. Pope? Thank you.
Okay, thank you.
No one else has signed up to be heard on the bill. Do you have anything you want to close with, Senator Cowser?
I think we've covered it. Chairman.
Okay. There is a law in our state against bribery, isn't there? Senator Watts, there's not. Okay. You only brought food to some people. What's the pleasure of the committee? Smell without a mouthful. Motion to pass by Senator Kirkpatrick. Is there a second? Second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. We have 4. All those opposed, like sign. We have 4. Chair will vote no. It fails 5-4. Five, is that right?
4, and you broke the tie.
Yeah, I broke the tie. The Cowsard rule you alerted me to. That concludes The items we have today, again, will be a committee hearing tomorrow at 10. In the event, we have Senate Bill 151 or Senate Bill 226 or Senate Bill 171. In the event any of those bills are ready for tomorrow, so please plan to join us tomorrow at 10. Thank you all for your work today. We got a lot done. I appreciate your work and sticking around with us. With that, we're adjourned.